I hope I am audible to everyone. Okay. A very good morning to everyone. It is my great pleasure to welcome you all to the today's lecture on the topic IPR legal aspect and filing. We are truly honored to have with us Dr. Anshu Singh, currently serving as the Research Establishment Officer at IIT Kanpur, where he managed the intellectual property and technology transfer portfolio. Dr. Singh brings with him over 12 years of rich experience across academia and industry with specialized expertise in intellectual property rights, operations management, and technology commercialization. He holds an MBA in operations and a post graduation diploma in IPR. And at IIT Kanpur, he plays a pivotal role in strategically overseeing IP assets, identifying innovations, and ensuring their effective protection and commercialization. His deep knowledge and practical insights make him the perfect speaker to guide us through the legal aspects of intellectual property rights and filing process, which are of immense relevance for budding professionals, researchers, and innovators alike. Let us all extend a very warm welcome to Dr. Anshu Singh and look forward to an enlightening and engaging session ahead. Please, sir, please go ahead.
Thank you, Swati, for detailed. So I think we have to wait for anyone, or we can start.
So we can start.
Okay, thank you. सो एमिटी ग्रुप का मैं थैंकफुल हूँ, और एमिटी की जितनी भी डिग्नेटरीज हैं जिन्होंने मुझे मौका दिया, ताकि मैं अपने एक्सपीरियंस आपके साथ शेयर कर पाऊँ। मुझे 12+ ईयर का एक्सपीरियंस है आईपी फाइलिंग और टेक ट्रांसफ़र में। और जैसा कि मुझे पता चला कि 2 दिन से ये एक 2 दिन का कोर्स है जो आप आईपी और टेक ट्रांसफ़र के बारे में सीख रहे हैं। तो आईपी के बारे में ज़्यादा टाइम ना लेते हुए, क्योंकि कल भी मुझे लग रहा है कि आईपी से रिलेटेड सारे सेशंस हुए होंगे और आईपी में ही आपने सारी चीज़ें सीखी होंगी कि टाइप्स ऑफ आईपी, ड्यूरेशन, टेन्योर, कैसे फाइल करना है, किस स्टेज पे क्या फाइल करना है। स्वाति, क्या मैं स्क्रीन शेयर कर सकता हूँ अपनी?
Yes, sir, you can.
विजिबल है स्क्रीन मेरी सबको?
Yes, sir, it's visible.
ओके, थैंक यू।
I hope everybody can see the screen, please. Yes, sir, please, you may go ahead, sir.
ठीक
Yes,
है,
sir.
थोड़ा सा मैं ये बताना चाहूँगा कि हमने अब तक किया क्या है। तो जो ये प्रीवियस 15 ईयर्स की जर्नी है, जो एक आपको चार्ट में दिख रही है, किस तरीके से हमने 2000 से स्टार्ट, तो हमने 1995 से किया है, लेकिन 15-16 ईयर की जो जर्नी है वो इस तरीके जर्नी जो है इस तरीके से चली है। और जो प्रीवियस 5 ईयर्स हैं जिसमें हमने 100 क्रॉस किया है पेटेंट फाइलिंग में, आईपी फाइलिंग में, वो 107, 109, 126, 157, यानी लास्ट ईयर में हमने 157 अचीव किया था। और अभी जो है वो हम 106 पे पहुंच चुके हैं, और होपफुली टारगेट है हमारा कि 200 क्रॉस करेंगे, लेकिन देखते हैं कैसे चलता है। 2024 का नेशनल आईपी अवार्ड भी हमें मिला था, जैसे आप देख सकते हैं, आईपी फाइलिंग में और वीपो मींस की इंटरनेशनल फाइलिंग में, पीसीटी फाइलिंग में। ठीक है। सो एक चीज ये कहना चाहूंगा कि जर्नी जो है बहुत छोटे से स्टार्ट होती है। अगर आज हम 157 पे हैं, 106 अभी अचीव कर चुके हैं, 200 टारगेट है। अगर आप पहले देखेंगे तो ये 2000 में 4 था, 2001 में 1 था, 2002 में 0 था। तो ये धीरे धीरे करके ही आपका आगे की तरफ प्रोग्रेस होता है। अगर हम आज ही सोचे कि हम एक ह्यूज नंबर फाइल करेंगे, वो नहीं हो पाता। ठीक है। थोड़ा सा रिकैप करते हुए चलते हैं। कल के सेशन में जो आपने देखा होगा, जो सुना होगा, जो सीखा होगा, वो ये है कि जो मोस्टली यूजेबल टाइप्स ऑफ आईपीआरस हैं, वो पहला आईपी आपका जो आईपीआर है वो पेटेंट होता है, जिसे इंडिया में बड़ा प्रोमिनेंट माना जाता है। सबकी अपनी अपनी स्पेसिफिकेशंस होती हैं, खासियत होती है। ऐसा नहीं है कि कोई डिजाइन या ट्रेडमार्क या कॉपीराइट है तो वो अंडर वैल्यू है। सबकी वैल्यू अपनी जगह पे अलग अलग है। जैसे कि पेटेंट अगर हम फाइल करते हैं तो प्रोडक्ट और प्रोसेस के लिए होता है, 20 ईयर्स तक वैलिड होता है। उसके बाद वो पब्लिक डोमेन में चला जाता है, कोई भी बना सकता है, कोई भी कमर्शलाइज कर सकता है, कोई भी सेल कर सकता है, आप रोक नहीं सकते। प्रोटेक्शन सिर्फ 20 ईयर्स तक का। इसी तरीके से डिजाइन है, जो एस्थेटिक प्रोटेक्शन होता है, जैसे कि हमारे शू कंपनी है या फिर कोई साड़ी कंपनी है जिसके डिजाइन मैटर करते हैं, वो एस्थेटिक प्रोटेक्शन आपका 10 ईयर्स के लिए होता है। और 5 ईयर्स के लिए फर्दर रिन्यू कर सकते हैं, उसके बाद वो पब्लिक डोमेन में चला जाता है, कोई भी कमर्शलाइज करे, कोई भी उसको सेल करे, प्रोटेक्शन करे, उसको कोई रोक नहीं सकता आफ्टर 10 ईयर्स, और 10 + 5 ईयर 15 ईयर्स। ट्रेडमार्क की अपनी इंपॉर्टेंस है। ट्रेडमार्क तो मुझे लग रहा है कि मोस्टली लोग जानते ही होंगे कि लोगो और वर्डमार्क, जिस तरीके से कोका कोला, पेप्सी, नाइकी या जो भी है, ठीक है, तो इसकी अपनी इंपॉर्टेंस है, क्योंकि ब्रांड नेम आपको एस्टेब्लिश करने के लिए ट्रेडमार्क आपको फाइल करना होगा। इसकी वैलिडिटी जो है 10 ईयर्स की होती है, लेकिन मल्टीपल ऑफ 10 ईयर्स, मतलब 10 10 ईयर्स करके आप इसको रिन्यू करते रह सकते हैं जब तक आप चाहते हैं, जब तक आपकी कंपनी चल रही है या ट्रेडमार्क आपके लिए वैल्यूएबल है, ठीक है। कॉपीराइट एक ऐसी चीज है कि इसकी अपनी वैल्यू है। आर्टिस्टिक वर्क, लिटरेरी वर्क, जैसे मूवीज, फिल्म, सॉन्ग्स, अगर आप ये सारी चीजें देखते हैं तो आपने देखा होगा यूट्यूब पे अक्सर आपने देखा होगा कॉपीराइट आ गया, कॉपीराइट आ गया, यानी अगर आपने किसी का सॉन्ग कुछ टाइम के बाद तक प्ले किया, इट मीन कि आई थिंक उन्होंने 6 सेकंड या 9 सेकंड, मुझे एग्जैक्ट याद नहीं है, उससे ज़्यादा अगर आप प्ले करते हैं तो फिर यूट्यूब उस पर कॉपीराइट लगाता है, ठीक है। तो कॉपीराइट प्रोटेक्शन, इसका जो टेन्योर होता है सबसे लंबा, जो टेन्योर क्या कहेंगे, इसकी वैलिडिटी, जो वैलिडिटी होती है, सबसे लंबी वैलिडिटी कॉपीराइट की होती है। इट मीन्स कि जिसने क्रिएट किया है कॉपीराइट, उसकी पूरी लाइफ तक वो उसी का होगा, और +16 ईयर्स, उसके बाद भी 60 सालों तक वो आ, उसी का आईपीआर बना जाएगा, ठीक है। ट्रेड सीक्रेट में किसी तरीके की रजिस्ट्रेशन की रिक्वायरमेंट नहीं होती है। ट्रेड सीक्रेट क्या होता है, जैसे आपने देखा होगा कि जहां पे टेस्ट की बात आती है, ठीक है, पेप्सी अगर आप पीते हैं उसका टेस्ट अलग है, कोका कोला ड्रिंक पीते हैं उसका टेस्ट अलग है, थम्स अप अलग है। तो बेसिकली इसको रिवील करने की जरूरत नहीं होती है, ये अपना ट्रेड सीक्रेट बचा के रखते हैं, और जो है इसके किसी भी रजिस्ट्रेशन की भी रिक्वायरमेंट नहीं होती है, मतलब वो उनका यूएसपी है बनाने, बेचने और सेल करने का, कि उनका टेस्ट है, ठीक है। नेक्स्ट पे आते हैं पेटेंट में। पेटेंट फाइल करते टाइम पे क्या दो चीजें होती हैं, यानी पेटेंट के लिए जरूरी नहीं है कि हाथ में आपके प्रोटोटाइप हो, प्रोडक्ट हो, तभी आप पेटेंट फाइल कर सकते हैं। आइडिएशन स्टेज पे भी पेटेंट फाइल किया जा सकता है, बस क्या है, प्रूफ ऑफ कॉन्सेप्ट आपका क्लियर होना चाहिए। और क्योंकि पॉपुलेशन इतनी है कि सब लोग एक ही आइडिया पे काम कर रहे होते हैं, सब लोग नहीं, मैं कह रहा हूँ मोस्टली लोग एक ही आइडिया पे काम कर रहे होते हैं, तो जैसे ही आइडिया आपको आया है और प्रूफ ऑफ कॉन्सेप्ट आपका क्लियर है, तो आप प्रोविजनल पेटेंट फाइलिंग की तरफ बढ़ सकते हैं, क्योंकि पेटेंट फाइलिंग की डेट ही मैटर करती है सारी चीज़ों में। बाई चांस आपने एक पेटेंट फाइल किया है आज की डेट में, कल मैं फाइल किया है मैंने, और अगर उसके ग्रांट की बात होती है, अवार्ड की बात होती है, तो फिर वो आपको मिलेगा, क्योंकि आपने एक दिन पहले फाइल किया है। सेम डे भी अगर किसी ने पेटेंट फाइल किया है, तो फिर जिसने पहले फाइल किया है, इट मीन्स कि टाइम ड्यूरेशन देखा जाएगा, कि जिसका फाइलिंग टाइम पहले है पेटेंट उसी को ग्रांट किया जाएगा, ठीक है। प्रोविजनल क्यों फाइल किया जाता है? प्रोविजनल फाइल इसलिए किया जाता है क्योंकि हमारे एक्सपेरिमेंट रिजल्ट्स अभी आए नहीं हैं, हम लोग जो है आइडिएशन स्टेज पे हैं, और प्रोविजनल फाइल करने के बाद हमें 12 मंथ्स का टाइम दिया जाता है, जिसमें आप ये कंप्लीट आफ्टर प्रोविजनल मीन्स की कैप फाइल कर सकते हैं, और अपने आइडिया को सिक्योर कर सकते हैं, ठीक है। दूसरा स्टेज होता है फाइलिंग का कंप्लीट, अगर आप प्रोविजनल नहीं फाइल करना चाहते हैं और प्रोटोटाइप आपके हाथ में है, तो एक्सपेरिमेंटल रिजल्ट्स आपके हाथ में हैं, प्रूफ ऑफ कॉन्सेप्ट सारी चीजें क्लियर हैं, अब आप पेटेंट फाइल करना चाहते हैं, तो आपको प्रोविजनल जाकर के कंप्लीट पेटेंट फाइल करना होता है। उस कंप्लीट पेटेंट फाइलिंग के बाद में आपका एग्जामिनेशन होगा, एग्जामिनेशन के बाद में पेटेंट ऑफिस में अगर फर्दर कोई ऑब्जेक्शंस होंगे तो उसमें हियरिंग होगी, और फिर जाकर के वो पेटेंट आपको ग्रांट होता है। दूसरा स्टेज होता है फॉरेन फाइलिंग का। कई बार जो स्टार्टअप्स होते हैं या फिर जो इनोवेटर्स होते हैं, वो पेटेंट को फॉरेन में भी फाइल करना चाहते हैं। उसके लिए सिंपल एक विंडो है कि 12 मंथ्स, कहीं भी पेटेंट कोई भी फाइल हुआ है पूरे वर्ल्ड वाइड में, अगर पेटेंट फाइल हुआ है और 12 मंथ्स के अंदर किसी दूसरी कंट्री में फाइल करना चाहिए, जैसे मान के चलते हैं कि आपने यूएस में पहला पेटेंट फाइल किया है, तो 12 मंथ्स की विंडो ही आपको मिलेगी किसी और दूसरी कंट्री में फाइल करने के लिए, अगर आप इंडिया में फाइल करना चाहते हैं, ठीक है। एक हमारे पास एक ऑप्शन, मतलब आईपी में एक ऑप्शन है पीसीटी फाइलिंग का। इसमें मैंने मेंशन नहीं किया है। पीसीटी फाइलिंग ये होती है कि अगर आप डिसाइड नहीं कर पा रहे हैं, इंडिया में हमने पेटेंट फाइल कर दिया और 12 मंथ से हम डिसाइड नहीं कर पा रहे हैं कि पेटेंट हमें किस किस ज्यूरिडिक्शन में फाइल करना है, मीन्स कि हमें यूएस में करना है, चाइना में करना है, जापान में करना है, कहाँ पे करना है, तो हम एक पीसीटी फाइल कर देते हैं जो हमारी 12 मंथ्स की विंडो है उसको वो एक्सटेंड करके 30 मंथ्स की विंडो में कन्वर्ट कर देता है। और फिर हम 30 मंथ्स तक यानी कि 2.5 साल तक ये डिसाइड कर सकते हैं, एक्सप्लोर कर सकते हैं कि हमारा पेटेंट फाइलिंग किस ज्यूरिडिक्शन में बेनिफिशियल होगा। ऐसा ना हो कि एक बेस्ट एग्जांपल है कि हम अम्ब्रेला बना रहे हैं और बेच रहे हैं और पेटेंट हमने ऐसी जगह फाइल किया जहां पे बारिश ही नहीं होती है, ठीक है। तो वहां पे आपका पैसा भी वेस्ट होगा, एफर्ट भी, टाइम भी, सारी चीजें। तो बेसिकली ज्यूरिडिक्शन डिसाइड करना होता है कि यूजिबिलिटी हमारे प्रोडक्ट की, हमारे पेटेंट की वहां पे होगी या नहीं होगी, ठीक। नेक्स्ट आते हैं कि पेटेंट हमें ग्रांट कब होता है। तो नॉर्मली 48 मंथ्स, एक्सपेडाइटेड मोड में 30th मंथ में हो जाता है, 30 महीने में। और आजकल पेटेंट ऑफिस में पेटेंट बहुत स्पीडली, जो बैकलॉग है क्लियर किया जा रहा है और स्पीडली ग्रांट हो रहे हैं। हमने पेटेंट 8-8 महीने में भी जो है अपने 8 महीने में पेटेंट ग्रांट देखे हैं, ठीक है। ठीक है, ये स्लाइड है जो कवर करती है फॉरेन और पीसीटी जो मैंने बताया था। तो इसमें फॉरेन फाइलिंग यानी कि 12 मंथ्स के अंदर डिसाइड करना होता है कि हमें किसी अदर ज्यूरिडिक्शन में फाइल करना है कि नहीं, अदर कंट्री में फाइल करना है कि नहीं। दूसरा पीसीटी फाइल कर सकते हैं, जो मैंने बताया था। पीसीटी फाइल करने के बाद 30 मंथ्स का विंडो ओपन हो जाता है, जो आप डिसाइड कर सकते हैं कि अच्छा खासा एक टाइम मिल जाता है कि हमारा प्रोडक्ट यहाँ पे चलेगा या नहीं चलेगा। दूसरा एक ईपी रूट है, वो भी 12 मंथ्स का है। यूरोपियन पेटेंट फाइल करने के लिए हमें यूरोपियन पेटेंट रूट के से जाना होता है, यूरोपियन कंट्रीज में पेटेंट फाइल करने के लिए, ठीक है। नेक्स्ट आता है आपका कि जैसे पेटेंट फाइल करना है, अभी तक तो ये सुनते आ रहे हैं कि हाँ पेटेंट फाइल करना है, और इन्वेंशन दैट आर नॉट पेटेंटेबल। मेन ये है कि हमें आइडिया तो आ गया, हमने उसके रिसर्च करनी स्टार्ट कर दी, उस पर टाइम इन्वेस्ट करना स्टार्ट कर दिया, ठीक है। लेकिन लास्ट में जाकर के पता चला कि ये पेटेंटेबल है ही नहीं, ठीक है। तो कुछ सेक्शन जो इंडियन पेटेंट ऑफिस के हैं जो बताते हैं कि ये चीजें जो है पेटेंट नहीं हो सकती हैं, इसके अलावा बाकी कुछ भी है वो पेटेंट होगा। जिसमें सेक्शन 3 बहुत इंपॉर्टेंट है कि सबसे पहले जब पेटेंट आता है, हमारे पास कोई भी इन्वेंशन आता है, तो सबसे पहले हम यही देखते हैं कि उसमें नॉवेल्टी है कि नहीं, मीन्स कि उसके अंदर कुछ नया है कि नहीं है। दूसरा, नॉन ऑब्वियस है कि नहीं। तीसरा, इंडस्ट्रियल एप्लीकेबिलिटी है कि नहीं, कि मतलब इंडस्ट्री में यूज हो सकता है कि नहीं है, ठीक है। इस तरीके के ये पैरामीटर्स हैं जिसे जज किया जाता है कि हम पेटेंट फर्दर फाइल करेंगे या नहीं करेंगे। जिसमें सेक्शन 3 का इंपॉर्टेंट रोल है। इसमें कुछ 12 से 13 सेक्शंस दिए हुए हैं, जिसमें इस सेक्शन में 12 से 13 क्लॉज दिए हुए हैं, जिसको रीड करके समझ करके आपको समझना है कि आगे पेटेंट के लिए बढ़ना है कि नहीं। अदरवाइज वो एग्जामिनेशन स्टेज पे रिजेक्ट हो जाएगा और आपको पेटेंट भी नहीं मिलेगा, तो आपका टाइम, पैसा, एफर्ट सब कुछ जो है वहाँ पे वेस्ट होगा। सेक्शन 4 जो है पेटेंट ऑफिस का, वो क्लियर कट कहता है कि एटॉमिक एनर्जी से रिलेटेड आप पेटेंट फाइल नहीं कर सकते हैं, तो इसमें इफ एंड बट है ही नहीं है, ठीक है। सेक्शन 35 डिफेंस एप्लीकेशंस के लिए होता है कि आप पेटेंट फाइल तो कर सकते हैं, लेकिन अगर पेटेंट ऑफिस को लगता है कि ये डिफेंस एप्लीकेशन है, तो वो उसको मिनिस्ट्री ऑफ डिफेंस में फॉरवर्ड कर देगा। जब वहां का क्लियरेंस मिलेगा तब जाकर के वो पेटेंट आपको ग्रांट होगा। और अगर वो डिफेंस एप्लीकेशन है तो फिर मिनिस्ट्री ऑफ डिफेंस की अलग से गाइडलाइन है कि पेटेंट ग्रांट तो होगा, लेकिन उसको कमर्शलाइज प्रोडक्शन कैसे करना है वो उनकी गाइडलाइन के अकॉर्डिंगली करना होता है। और दूसरा, सेक्शन 35 लगने के बाद फॉरेन पेटेंट फाइलिंग जो है वो उनकी गाइडलाइन के अकॉर्डिंग होगा। ऐसा नहीं है कि आपने जो है डिफेंस एप्लीकेशन पेटेंट ऑफिस में फाइल करी और तुरंत ही आप जो है फॉरेन में पेटेंट एप्लीकेशन करने चले गए, ठीक है। तो ये बेसिकली जो, क्योंकि डिफेंस एप्लीकेशंस हैं, थोड़ा सा इस पे गवर्नमेंट ये देख के चलती है कि अगर कुछ इंपॉर्टेंट एप्लीकेशन है तो वो इंडिजीनियस है, तो वो हमारे यूज के लिए हो, ना कि हम यूज ना कर पाए और पहले दूसरे को देना स्टार्ट कर दें, ठीक है। मोटा मोटा पर्पज यही है इसका। नेक्स्ट पे आते हैं, जो सेक्शन 3 है, अगर आप गूगल करेंगे या आपको इजीली मिल जाएगा कि जो इंडियन पेटेंट एक्ट है, सेक्शन 3, इसमें कौन कौन से क्लॉज हैं जो मना करते हैं कि ये चीजें पेटेंट नहीं होंगी। इसको थोड़ा सा सिंपल लैंग्वेज में समझने की कोशिश करेंगे। इसमें सारे ही सेक्शन के क्लॉज जो हैं वो बहुत इंपॉर्टेंट नहीं है। लगभग 3 से 4 जो क्लॉज हैं वही एप्लीकेबल होते हैं पेटेंट फाइलिंग के टाइम पे पेटेंट ऑफिस की तरफ से, ठीक है। सबसे पहले सेक्शन 3 ये आता है, बहुत इंपॉर्टेंट नहीं है, लेकिन बस ये है कि फ्रिवलस नहीं होना चाहिए। मतलब कि एक रिस्ट बैंड में आपने रिस्ट बैंड बनाया जो आपने मार्केट में ये कहना कहा कि ये मनी अट्रैक्ट करता है, इसे आप पहनोगे तो आपके पास धन वर्षा होगी, धन लाभ होगा। इस तरीके के पेटेंट नहीं होते हैं, ठीक है। ऑब्वियसनेस वाली जो बात कर रहा था मैं कि अगर आपने कोई मैग्नेट बनाया है जो एनवायरनमेंट से गोल्ड एक्सट्रैक्ट करता है, ऐसा भी पेटेंट नहीं होगा, ठीक है। जो नेचुरल लॉज होते हैं उनके अगेंस्ट में नहीं होना चाहिए। सेक्शन 3 का बी जो है बेसिकली ये मोरालिटी को लेकर के चलता है कि कोई भी इन्वेंशन इस तरीके का नहीं होना चाहिए जो मोरालिटी को हैम्पर करे, ठीक है। जैसे कि एग्जाम्पल के लिए मैंने दिया हुआ है कि ए मशीन फॉर मेकिंग काउंटरफिट करेंसी नोट्स, मतलब नकली नोट बनाने की मशीन आप बना लो और उसे कहो कि हम पेटेंट करने चलेंगे, तो वो नहीं मिलेगा, ठीक है। एक कोई फॉर्मूला या केमिकल गैस आपने बनाई है जो वॉर में यूज होने वाली है, उसका पेटेंट नहीं मिलेगा, ठीक है। तो सेक्शन बी मोस्टली नहीं लगता है कोई ऐसा इन्वेंशन करता नहीं है, और करता भी है तो पेटेंट करने के लिए कभी नहीं जाता, लेकिन समझना जरूरी है सिंपल लैंग्वेज में। सेक्शन 3 इंपॉर्टेंट है, सेक्शन 3 का सी इंपॉर्टेंट है, रीजन बीइंग कि कई लोग कुछ भी कहीं से ढूंढ के ले आएंगे और पेटेंट करने के लिए उसको चल देंगे। बेसिकली डिस्कवरी अलाउड नहीं है। अगर कुछ भी बनाया है वो आपका बनाया हुआ होना चाहिए, ये नहीं कि किसी जंगल में गए, किसी पौधे से कोई फल तोड़ा या फिर कुछ लकड़ियां हैं जिसे हम लेकर के चले आए और हम कहें कि हम ये हमारा इन्वेंशन है, हमने ढूंढा है और हम इसे पेटेंट करना चाहते हैं, तो ये अलाउड नहीं है, डिस्कवरी अलाउड नहीं है किसी भी तरीके की। नोन सब्सटेंसेस, जैसे एग्जांपल के लिए मैंने दिया हुआ है कि जो सेक्शन 3D, ये भी पेटेंट ऑफिस की तरफ से खूब लगाया जाता है। इसका रीजन ये है कि कई तरह के नोन सब्सटेंसेस को मिला करके, जैसे कि आप देख रहे हैं कि टूथपेस्ट में अगर टर्मरिक मिला दिया जाए, तो क्योंकि वूंड हीलिंग उसके अंदर स्पेसिफिकेशंस होते हैं, तो अगर आप कहो कि टूथपेस्ट में हल्दी को मिला करके पेटेंट लिया जा सकता है, तो नहीं लिया जा सकता। ये एग्जांपल के लिए लिया हुआ है मैंने। बेसिकली उसकी तो प्रॉपर्टीज टर्मरिक की है ही, सबको पता है कि वुंड हीलिंग होती है, एंटीसेप्टिक होता है, तो फिर जो है इस पे पेटेंट नहीं मिलेगा, ठीक है। ऑल नोन सब्सटेंसेस मतलब ऑलरेडी अवेलेबल है, नोन है सबकी नॉलेज में, उसका आपको पेटेंट नहीं मिलेगा। आपकी तरफ से कुछ उसमें इंटरवेंशन होना चाहिए, आपकी तरफ से कुछ उसमें योगदान दिया हुआ होना चाहिए। सेक्शन 3E ये भी खूब लगाया जाता है। सेक्शन 3E इसमें क्या है कि किन्हीं भी दो चीजों को मिला करके आप पेटेंट करने जा रहे हैं, वो आपको नहीं मिलेगा। एग्जाम्पल के लिए मैंने आपको दिया हुआ है कि मिक्सिंग शुगर एंड वाटर, कि मतलब एक स्वीट वाटर आपने बना लिया, अब आप कहो कि इसको पेटेंट करने चलते हैं, तो उसका भी नहीं मिलेगा पेटेंट, ठीक है। पेटेंट कब मिलेगा कि अगर आपने शुगर को वाटर के साथ मिक्स किया है और उसमें तीसरी चीज आपको निकल के आ रही है, उसका पेटेंट मिलेगा। समझने के लिए और एक मैंने इलस्ट्रेशन दिया हुआ है कि 1+1 अगर 2 हो रहा है तो उसमें पेटेंट नहीं होगा। 1+1 अगर आप किसी तरीके से 3 कर दे रहे हैं, मैथमेटिकली पॉसिबल नहीं है, लेकिन आप जब R&D करते हो, R&D करने का मतलब कोई दो सब्सटेंस आपने लिए, उनको मिलाया, उसमें कुछ भी किया, हीटिंग किया, कोल्ड किया किसी सर्टेन टेम्परेचर पे, और एक कोई तीसरा प्रोडक्ट निकल के आ रहा है, उसका आप पेटेंट ले सकते हैं, वो अलाउड होगा, अलाउड होगा। ठीक है। ये भी रीअरेंजमेंट है कि बहुत सारी चीज़ों को मिला करके आपने अगर इकट्ठा कर लिया है और आप उसका पेटेंट करने चल दे रहे हैं, तो वो अलाउड नहीं है। जैसे एग्जांपल के लिए दिया हुआ है कि ए टेबल विद ए फैन एंड ए लैंप अटैच्ड, कि मतलब एक टेबल लिया आपने, उस पर फैन लगाया, एक लैंप लगा दिया और ये हमारा इन्वेंशन है, ऐसा नहीं होगा, वो पेटेंट अलाउड नहीं होगा, ठीक है। थोड़ा स्पीडली कवर करते हैं। हाँ, इसमें पेटेंट कैसे अलाउ हो सकता है, एक अगर आप देखेंगे, एक स्मार्ट फ्रीज दैट सेंस टेम्परेचर, एक फ्रिज है जो टेम्परेचर को सेंस करता है, सेंस करने के साथ साथ कूलिंग को एडजस्ट करता है कि कूलिंग कितनी होनी चाहिए, और उसमें एक ऐप आपने ऐड कर दिया जिस ऐप पे आपको नोटिफिकेशन भी आता है, तो इस तरीके के पेटेंट जो है अलाउड होते हैं, क्योंकि इसमें बेसिकली कि अगर मान लीजिए टेबल का एग्जांपल लेते हैं, एक टेबल पे आपने 3 इक्विपमेंट्स दिए हैं, वो तीनों इक्विपमेंट्स अपना इंडिविजुअली वर्क कर रहे हैं, लैंप जो है लाइट दे रहा है, फैन जो है हवा दे रहा है, और एक कंप्यूटर अगर आप रख देते हैं तो उसमें कंप्यूटिंग हो रही है, तीनों अगर अलग अलग काम कर रहे हैं वो पेटेंट अलाउड नहीं होगा। तीनों अगर कंबाइन हो करके, मतलब एक साथ काम कर रहे हैं और रिजल्ट दे रहे हैं, तो फिर वो पेटेंट अलाउड हो, ठीक है। मैथ एग्रीकल्चरल मेथड जो है अलाउड नहीं है, क्योंकि गवर्नमेंट की तरफ से है कि अगर इस कोई मेथड को पेटेंट करता है तो फिर ये दूसरों के लिए बार होगा, वो उस मेथड को यूज नहीं कर पाएंगे, तो इसलिए है कि पब्लिक वेलफेयर के लिए और फूड सिक्योरिटी के लिए कि आप एग्रीकल्चरल मेथड्स जो है पेटेंट नहीं कर सकते हैं, ठीक है। सेक्शन 3 आई। इसमें भी क्या है कि जैसे एग्जाम्पल के थ्रू अगर आप समझेंगे कि मेडिकल ट्रीटमेंट शुड रिमेन फ्रीली अवेलेबल फॉर पब्लिक हेल्थ एंड वेटरनरी वेलफेयर। बेसिकली सेक्शन 3 जो है ये कहता है कि आप जो है ट्रीटमेंट के मेथड्स को पेटेंट नहीं कर सकते। जैसे अगर कोई डॉक्टर करता है कि मैं एक यूनिक वे में सर्जरी करता हूं और मैं इसको पेटेंट करना चाहता हूं, तो वो आप नहीं कर सकते। ठीक है। ए मेथड फॉर ट्रीटिंग मलेरिया बाय गिविंग ए स्पेसिफिक डोज ऑफ मेडिसिन, मतलब अगर कोई कहे कि एक स्पेसिफिक डोज दे करके मलेरिया को ट्रीट किया जा सकता है और मैं इसका पेटेंट लेना चाहता हूं क्योंकि मैं ही जानता हूं कि ये डोज कितनी देनी है, तो उसका पेटेंट नहीं लिया जा सकता। ठीक है। एक और एग्जांपल दिया है मैंने कि अगर आप स्टिचेस लगा रहे हैं, किसी को चोट लगी है और स्टिचेस लगा रहे हैं, अब वो कहे कि क्रॉस सेक्शन स्टिचेस लगाने से या और अलग तरीके से स्टिचेस को लगाने से पेटेंट लिया जा सकता है, तो पेटेंट नहीं लिया जा सकता। ठीक है। प्लांट की वैरायटी पे पेटेंट नहीं लिया जा सकता है। प्लांट वैरायटी के लिए अलग से गवर्नमेंट ऑफ इंडिया ने एक सेक्शन बनाया हुआ है जिसमें प्लांट वैरायटीज जो है कवर की जाती हैं, जिसमें पेटेंट नहीं होता है बेसिकली। सेक्शन 3 के आजकल क्योंकि AI ML और सॉफ्टवेयर का ही टाइम चल रहा है, आप देख रहे होंगे मशीन लर्निंग और AI आर्टिफिशियल इंटेलिजेंस है। जनरली हमारे यहाँ थंब रूल था कि इंडिया में सॉफ्टवेयर पेटेंट अलाउड नहीं है। तो उसमें सेक्शन 3 के जो पेटेंट ऑफिस सबसे ज्यादा ऑब्जेक्शन लगाता है वो सेक्शन 3 के पे लगाता है। ठीक है। तो इसमें समझते हैं कि कंप्यूटर प्रोग्राम कोई है वो अलाउड क्या है और क्या नहीं है। जैसे कि मैथमेटिकल मेथड, ए फॉर्मूला टू कैलकुलेट प्राइम नंबर्स, कि अगर आप कैलकुलेशन के लिए सिर्फ एक कोई सॉफ्टवेयर बना रहे हैं वो अलाउड नहीं है। बिजनेस मेथड जैसे न्यू वे ऑफ मैनेजिंग स्टॉक ट्रेडिंग, ये भी अलाउड नहीं है। अलाउड क्या है? सॉफ्टवेयर प्लस हार्डवेयर, जिसे एम्बेड सिस्टम कहा जाता है, ये इंडिया में अलाउड है। एग्जाम्पल के लिए अगर मैं एग्जाम्पल लेता हूं, मान लीजिए कि आपने कोई एक ऐसा सॉफ्टवेयर बनाया है जो किसी इमेज को एनहांस करता है, बेसिकली उसके पिक्सल्स एनहांस कर रहा है, उसमें क्लैरिटी लेकर के आ रहा है, ब्लरीनेस उसका हटा दे रहा है। तो बेसिक है तो ये सॉफ्टवेयर, लेकिन इसके लिए किस चीज की रिक्वायरमेंट होगी? प्राइमरी रिक्वायरमेंट होगी कैमरा की, जो एक पिक्चर क्लिक करेगा। यानी कैमरा आपका हार्डवेयर हो गया, प्लस आपने जो सॉफ्टवेयर बनाया इसको एम्बेडेड सिस्टम कहते हैं। एम्बेडेड सिस्टम में जो हार्डवेयर है वो ऑलरेडी नोन है तो भी अलाउड है। बेसिकली कैमरा आपका ऑलरेडी नोन प्रोडक्ट है, उससे आप पिक्चर ले रहे हैं, पिक्चर जो है आपके सॉफ्टवेयर में आ रही है, सॉफ्टवेयर उसको प्रोसेस कर रहा है और उसकी क्वालिटी को इन्हांस कर रहा है। ठीक है। तो इस तरीके के पेटेंट्स जो है, जो सॉफ्टवेयर पेटेंट जिन्हें कहा जाता है, ये अलाउड है। और जो मैथमेटिकल मेथड, बिजनेस मेथड, ये सब वाले नहीं। जैसे एल्गोरिदम, प्योर एल्गोरिदम है, वो अलाउड नहीं। ठीक है। तो एम्बेड सिस्टम होना चाहिए, यानी कि आपका सॉफ्टवेयर किसी ना किसी एक हार्डवेयर के साथ मिलकर काम कर रहा हो, तभी वो अलाउड है। ठीक है। सेक्शन 3 के बहुत इंपॉर्टेंट है अपने पेटेंट ऑफिस में या इंडियन पेटेंट ऑफिस के लिए। ठीक है। नेक्स्ट आते हैं, आपका जो है पेटेंट तो हमने कर लिया। पेटेंट का जो अल्टीमेटली उसका पर्पस है वो है रेवेन्यू। कि अगर हम कोई पेटेंट फाइल करते हैं, प्रोटेक्शन ले रहे हैं, एफर्ट भी दे रहे हैं, टाइम भी दे रहे हैं, पैसा भी उसमें इन्फ्यूज कर रहे हैं, तो उसका अल्टीमेट गोल ये होना चाहिए कि हमें उसे रेवेन्यू जनरेट करना है। अब रेवेन्यू जनरेट करने के कौन कौन से स्टेजेस हैं? जैसे कि आपको पहले आइडिया आया, आइडिया के बाद आपने उसका आईपी क्रिएशन किया, मीन्स कि वो किसी भी कैटेगरी में फॉल कर रहा है, डिजाइन है, पेटेंट है, कॉपीराइट है, जहां पे भी है, उसको आपने सिक्योर किया। उसके बाद अब क्या करना है? तो उसमें 3 स्टेजेस होते हैं। सबसे पहले अगर आपने आईपी क्रिएट कर लिया है, आपकी बैंडविड्थ इतनी नहीं है कि आप उसकी मैन्युफैक्चरिंग कर पाओ, फर्दर R&D कर पाओ, या फिर उसका कमर्शलाइजेशन कर पाओ और मार्केट में लेकर के आओ, तो एक ऑप्शन आता है लाइसेंसिंग। कि हम किसी भी सिमिलर काइंड ऑफ इंडस्ट्री जो उस डोमेन में वर्क कर रही है उससे अप्रोच करना स्टार्ट कर देते हैं। अपने पेटेंट जो आईपी हमने फाइल किया है उसको हम वहां पे बताना शुरू कर देते हैं कि हमारे पास एक नॉवल आइडिया है जिसमें हमने आईपी सिक्योर किया हुआ है और हम ये आपको देना चाहते हैं। तो अगर कंपनी इंटरेस्टेड होती है तो वो आपका वो टेक्नोलॉजी जो है आपसे बाय कर लेती है, सर्टेन टर्म एंड कंडीशंस पे, जो आपके म्यूचुअल होते हैं कि हम क्या लेंगे क्या देंगे। और दूसरा जो है ठीक है, लाइसेंसिंग के टर्म्स की मैं थोड़ा सा आगे चल करके बात करूंगा। नेक्स्ट स्टेज पे आते हैं कि अगर आप कैपेबल हैं, यानी कि जो आईपी क्रिएशन है, आईपी क्रिएशन जो फर्स्ट स्टेज है, यहाँ पे जो इंडस्ट्री है, कोई भी इंडस्ट्री इंटरेस्ट कम शो करती है। रीजन बीइंग कि इंडस्ट्री को रेडी टू मूव प्रोडक्ट चाहिए होता है कि आप जो भी बना के दो वो तुरंत ही लॉन्च करें और मार्केट में उसको कमर्शलाइज करें। ठीक है, तो अगर बैंडविथ है आपके पास और आप फर्स्ट स्टेज ना चूज करके सेकंड स्टेज तक पहुंचते हैं, तो यहाँ पे कमर्शलाइजेशन और लाइसेंसिंग के चांसेस जो हैं वो आपके बढ़ जाते हैं। ठीक है, जिसमें करना क्या होता है कि आपको किसी ना किसी तरीके से प्रोडक्ट या प्रोटोटाइप लेवल पे पहुंचना होता है। ठीक, प्रोटोटाइप यानी रफ फॉर्म ऑफ प्रोडक्ट की प्रोडक्ट बनने से, फिनिश प्रोडक्ट बनने से पहले की जो स्टेज होती है उसे प्रोटोटाइप बोलते हैं। ठीक, इस स्टेज पे आकर के भी फिर दोबारा फर्दर इंडस्ट्री को हम अप्रोच करते हैं, और इंडस्ट्री का इंटरेस्ट जो है वो शो इजिली होता है। रीजन बीइंग कि आप प्रोडक्ट या प्रोटोटाइप स्टेज पे होते हैं और उन्हें वो फर्दर छोटी मोटी R&D करने के बाद उसको मार्केट लॉन्च कर सकते हैं। अगर बैंडविड्थ आपकी अच्छी है, ठीक है, तो आप उस मैन्युफैक्चरिंग और कमर्शलाइजेशन के स्टेज पे जा सकते हैं। ठीक, नेक्स्ट। हाँ, जो सेशन का आपका थीम है, वो 2 दिन के सेशन का वो ये है कि प्रॉब्लम और बेसिकली चैलेंजेस और अपॉर्चुनिटी, यानी चैलेंजेस प्रॉब्लम है और अपॉर्चुनिटीज यानी कि सॉल्यूशन अगर आपने ढूंढ लिया है तो वो आपके लिए अपॉर्चुनिटी बन जाता है। ठीक है, तो सबसे पहले करना क्या है कि आइडेंटिफाई प्रॉब्लम, यानी प्रॉब्लम को आइडेंटिफाई करना है। प्रॉब्लम आइडेंटिफाई कैसे करते हैं, क्योंकि जिन प्रॉब्लम्स के साथ में हम डेली डे टू डे वर्क करते रहते हैं, हम यूज टू हो जाते हैं, वो हमें प्रॉब्लम में दिखती नहीं है। जैसे अगर मैं बेस्ट एग्जांपल लूं कि अगर कोई अर्बन एरिया का रेजिडेंट, मतलब अर्बन एरिया में कोई रह रहा है और रूरल एरिया में उसे जाके रहना पड़े, तो 2-3 दिन मजा आएगा, उसके बाद उसे पता चलने लगेगा ये प्रॉब्लम है, वो प्रॉब्लम है, यहाँ ये दिक्कत है। तो बस वही प्रॉब्लम हमें आइडेंटिफाई करनी है, जहां भी हम रह रहे हैं अपने चारों तरफ देख के कि कहाँ पे क्या लैकनेस है, क्या कमी है और इसे कैसे इंप्रूव किया जा सकता है। ठीक है, तो आइडेंटिफाई प्रॉब्लम एंड फाइंड सॉल्यूशंस। जो पेटेंट, मैंने आपको बताया था कि पेटेंट को सबसे पहले सेक्शंस के थ्रू चेक करना होता है कि ये पेटेंटेबल है कि नहीं, और दूसरा जो है हम आइडिया जो सिक्योर करना चाह रहे हैं, जिस आइडिया पे काम करना चाह रहे हैं, वो जो है मार्केट वाइबल है कि नहीं, वो मार्केट में चल पाएगा कि नहीं। ये हमारा एक पेटेंट एप्लीकेशन है, IIT कानपुर ने फाइल किया था। बहुत अच्छा पेटेंट एप्लीकेशन है। इसमें क्या है कि फ्यूल क्वांटिफायर है, मींस कि एक ऐसी डिवाइस कार में लगा दी जाएगी जिसमें अगर कोई फ्यूल आप गाड़ी में फ्यूल डलवाते हैं तो वो क्वांटिफाई करेगी, बेसिकली उसको क्वांटिटी बता देगी आपको कि इसमें कितना फ्यूल जो है डाला गया है। जैसे कि आपने देखा होगा कि कई न्यूज़ आती रहती थी कि पेट्रोल पंप पे फ्यूल चोरी हो रहा है, कम डालते हैं, पैसे ज़्यादा लेते हैं, ये सारी चीज़ें हैं। तो ये बहुत बढ़िया इन्वेंशन था जो कि इस चीज़ को रोक सकता था। ठीक है, लेकिन इसके कमर्शलाइजेशन और लाइसेंसिंग में सबसे बड़ी प्रॉब्लम ये आई। देखिए, इन्वेंशन कितना अच्छा है, ये पेटेंट ग्रांटेड भी है पेटेंट ऑफिस की तरफ से हमें, लेकिन ये कमर्शलाइज नहीं हो पा रहा था। इसका रीजन सबसे बड़ा ये था कि ये एक इलेक्ट्रॉनिक डिवाइस है और फ्यूल जो है, पेट्रोल जो है वो इन्फ्लेमेबल होता है, मीन्स कि कहीं भी शॉर्ट सर्किट या कुछ ऐसी चीज होगी और तुरंत ही जो है ये ब्लास्ट करेगा। तो इसीलिए इतना अच्छा इन्वेंशन होने के बाद भी, फाइल करने के बाद भी, ग्रांट मिलने के बाद भी, इसको इसके कमर्शलाइजेशन में सबसे बड़ा ड्रॉबैक ये था कि ये इलेक्ट्रॉनिक प्रोडक्ट था। ठीक है, तो इसीलिए मेरा कहना है कि जब आपको आइडिया आता है, सबसे पहले उसको हर तरीके से एक्सप्लोर करके देखो कि उसमें कोई जो है लिमिटेशंस ना हो। ठीक, 2 मिनट का पॉज ले लेंगे। रीजन ये 2 फिगर्स हैं, अगर आप देखें इसमें इमेजेस में कि क्या प्रॉब्लम स्टेटमेंट है, अगर किसी को यहाँ पे दिखाई दे रहा हो तो। जो ऑनलाइन जुड़े हैं वो भी बता सकते हैं अगर किसी को कुछ प्रॉब्लम स्टेटमेंट यहाँ पे समझ में आ रही हो। चलिए एक्सप्लेन करता हूँ मैं कि यहाँ ये क्लासरूम है जहाँ पे बच्चे नीचे बैठ के पढ़ रहे हैं, कुछ इन्होंने बिछाया हुआ है नीचे चादर वगैरह और जो सारी चीज़ें, और एक यहाँ पे कुछ वेजिटेबल है, चाहे ये फ्रूट्स हैं जो सड़क पे फेंके जा रहे हैं। ठीक है, नेक्स्ट स्लाइड में प्रॉब्लम स्टेटमेंट साफ साफ दिख रही है कि नदी है जिसमें इन्होंने कुछ कचरा टाइप का फेंका हुआ है, फूल वगैरह डाले हुए हैं। ठीक है, तो अभी तो ये इस स्टेज पे भी यहाँ पे प्रॉब्लम ही है, इस स्टेज पे भी यहाँ पे प्रॉब्लम ही है। ठीक है, जो ये प्रॉब्लम है, इस प्रॉब्लम का हमारे यहाँ के अगर आप गूगल करेंगे तो ईशान सदाशिवन, उन्होंने एक कंपनी बनाई प्रोसॉक करके। और इस प्रॉब्लम का सॉल्यूशन ढूंढा। इस प्रॉब्लम के सॉल्यूशन में उन्होंने जो है एक इस तरीके का बैग डिजाइन किया। ठीक है, ये पेटेंट नहीं है, ये डिजाइन एप्लीकेशन है सिंपल। लेफ्ट साइड पे आप देख रहे होंगे कि एक बच्चा जो नीचे बैठा हुआ था उसे किस तरीके से एक टेबल मिल गई, बैग भी है साथ में। इस टेबल को फोल्ड करके इस बैग में डाला भी जा सकता है। तो बेसिकली एक छोटा सा सॉल्यूशन उन्होंने प्रोवाइड कर दिया कि बच्चे जो है इस तरीके से नीचे बैठ के भी एक अच्छे पोजीशन में लिख सकते हैं। ठीक है, और अभी इस कंपनी का रेवेन्यू एक अच्छा खासा रेवेन्यू है। बहुत सारे स्टेट्स हैं इंडिया में जिन्होंने इनको बल्क ऑर्डर्स दिए हुए हैं अपने प्राइमरी स्कूल्स में बच्चों को बांटने के लिए। ठीक है, तो बहुत छोटा सा प्रॉब्लम था जो मुझे लग रहा है कि सब लोगों ने देखा होगा, लेकिन सॉल्यूशन ये लेकर के आए और इन्होंने एक डेस्क किट नाम से एक बैग प्रिपेयर किया और उसमें फोल्डेबल सिस्टम बनाया कि उसको आप बैग में भी डाल सकते हो और ओपन भी कर सकते हो इस तरीके से। ठीक है, तो छोटी सी प्रॉब्लम का सॉल्यूशन निकाल करके एक अच्छा खासा इन्होंने स्टार्टअप शुरू कर दिया है। नेक्स्ट अगर प्रॉब्लम है तो ये फूल की प्रॉब्लम है। इन्होंने एक फूल, अगर कोई भी गूगल कर रहे हैं तो देख रहे होंगे कि फूल एक कंपनी है जो आईआईटी कानपुर में इंक्यूबेटेड थी। और इन्होंने जो फ्लावर्स जो इसमें नदी नालों में किनारे फेंके जाते थे उसको फेंकने की बजाय उसे कलेक्ट करना स्टार्ट किया और उससे इन्होंने इंसेंस स्टिक, धूप और ये सारी चीजें बनाई। एक अच्छा खासा इनका भी स्टार्टअप है। अगर आप गूगल करेंगे तो बहुत सारे सेलिब्रिटीज ने इसमें इन्वेस्ट भी किया हुआ है। ठीक है, नेक्स्ट है कि ये जो टोमेटोज हैं सड़क पे फेंके जा रहे हैं, मुझे लग रहा है प्रोडक्शन बहुत हाई था, मार्केट नहीं था, या जो भी उनको जो एमएसपी होती है, जो वैल्यू मिलती है वो अच्छी नहीं मिल रही थी। उसके लिए एक सोल्यूशन ये लेकर के आए। ये निक्की झा है, निक्की कुमार झा। इन्होंने शार्क टैंक वगैरह में भी गए, अगर गूगल करेंगे तो आपको मिलेगा। इनकी कंपनी है सप्तकृषि, जिन्होंने एक सब्जी कोठी का एक सोल्यूशन प्रोवाइड किया जिसमें विदाउट रेफ्रिजरेंट कि आपको किसी भी तरीके का कोई फ्रीजर यूज नहीं करना है, रेफ्रिजरेटर यूज नहीं करना है, और आपको टमाटर जो टोमेटो है जो डे 1 में जैसा होगा वो 40 डेज भी होगा। मतलब मुझे लग रहा है कि टमाटर एक ऐसी चीज है जो बहुत जल्दी खराब होती है। ठीक है, तो अगर आप देखेंगे, बेसिकली मेरा बताने का मेन पर्पज सिर्फ और सिर्फ यही है कि जहां भी प्रॉब्लम है वहीं पे सॉल्यूशन है। बस ढूंढने की जरूरत है और उसमें काम करने की जरूरत है। ठीक है, नेक्स्ट जो सॉल्यूशन हमें चाहिए होता है, बेसिकली पेटेंट का आइडिया भी है हमारे पास, सारी चीजें हैं, लेकिन जो सबसे मेन प्रॉब्लम है वो फाइनेंशियल प्रॉब्लम होती है, मार्केट नेटवर्किंग, इन सब की प्रॉब्लम होती है। तो जिसके लिए इंक्यूबेटर्स बनाए जाते हैं, गवर्नमेंट ऑफ इंडिया ने खूब सारे इंक्यूबेटर बनाए जिसमें एसआईसी भी है और भी कई कॉलेजेस हैं जहां पे आप अपनी एलिजिबिलिटी के अकॉर्डिंग क्या स्कीम और क्या चल रही है, उठा लो जरा, कौन सी स्कीम अभी अवेलेबल है, क्या ग्रांट मिल रहा है, क्या एलिजिबिलिटी है, क्या क्वालिफिकेशन आपकी रिक्वायरमेंट होनी चाहिए, और किस डोमेन का इन्वेंशन होना चाहिए, इसके अकॉर्डिंगली बहुत सारी स्कीम्स चलती हैं जिसमें आप अप्लाई कर सकते हैं। जिसमें पेटेंट फाइलिंग का भी पैसा मिल जाता है आपको किसी किसी स्कीम में। उसके बाद उसके प्रोटोटाइप डेवलपमेंट के लिए भी पैसा मिलता है। और इंक्यूबेशन में अगर आप इंक्यूबेशन सेंटर में अगर आप इंक्यूबेट करते हैं तो वहाँ पे आपको नेटवर्क्स भी मिल जाते हैं कि फंडिंग जहाँ से मिले, या फिर मार्केट लाइसेंसिंग आपकी कैसे हो सकती है, सब लाइसेंसिंग कैसे हो सकती है, ये सारी चीज़ें। ठीक है, तो इसमें इंक्यूबेटर का बेसिकली मेन रोल होता है। यहाँ भी आपको एक प्रॉब्लम दिख रही होगी। ठीक है, फेमस है काफी। आप अक्सर देखते होंगे, आप गेहूं और धान के सीजन में जब भी कटाई होती है हरियाणा में, वो पराली और ये जलाई जाती है, खूब न्यूज होती है, दिल्ली वालों को प्रॉब्लम होती है ना, इन सारी चीजों से। तो ये भी एक प्रॉब्लम है जिसका कुछ सोल्यूशन सब निकालने की कोशिश कर रहे हैं कि जो वेस्ट होता है उससे कई लोग प्लेट्स बना रहे हैं डिस्पोजेबल, कुछ ग्लासेस बन रहे हैं, कुछ इस तरीके से बन रहे हैं। बेसिकली काम कर रहे हैं लोग, यानी प्रॉब्लम के साथ साथ सोल्यूशन भी ढूंढ रहे हैं। ये भी एक प्रॉब्लम है मेरे पास। जॉब से- ठीक है, यहाँ भी एक प्रॉब्लम है, और ये हर घर की प्रॉब्लम है मुझे लग रहा है कि जो भी रेपिलेंट यूज करते हैं, मॉस्किटो रेपिलेंट, जब भी उसके अंदर वो लिक्विड सॉल्यूशन थोड़ा सा बचता है तो लोग उसको उल्टा करके लगा देते हैं ताकि वो यूज हो जाए। ठीक है, लेकिन मुझे नहीं लग रहा कि अभी कोई सॉल्यूशन इसका आया भी है। मतलब एग्जांपल के लिए मैं कह रहा हूँ, जरूरी नहीं है कि इसी पे आप काम करना स्टार्ट स्टार्ट करें। लेकिन क्या है कि जो इसका रिफिल है उसको डिजाइन ऐसा कुछ किया जा सकता है कि जिसमें ये जो थोड़ा सा लिक्विड नीचे बचता है वो वेस्ट ना हो, और दूसरा इस तरीके से उल्टा करके ना लगाना पड़े, क्योंकि इसमें से लीकेज के चांसेस भी रहते हैं, जो लिक्विड इसका हार्मफुल होता है। ठीक। ये दिखाने का पर्पस मेरा इतना है कि छोटी छोटी जगह पे भी प्रॉब्लम्स रहती हैं, बस हम क्या है उसको इग्नोर करके चलते हैं, उसका कोई सॉल्यूशन नहीं ढूंढते। ये एक प्रॉब्लम सबने देखी होगी, अगर किसी क्रॉसिंग पे कोई कभी खड़ा हुआ होगा, तो ये बैरल्स हैं जिसमें डीजल पेट्रोल इस तरीके भर के जाता है, जिसमें स्पिलिंग होती है। तो इसका भी सॉल्यूशन ढूंढा जा सकता है, लेकिन हो रही है, चल रहा है, जैसे चल रहा है वो चलता जा रहा है। अलग से कोई कंटेनर लगा दिया जाए, नीचे कुछ एक ऐसा स्टोरेज टैंक लगा दिया जाए जो भर करके उसके अंदर आ जाए। ठीक है। तो बेसिकली हमारे चारों तरफ जो प्रॉब्लम्स हैं वो हैं, कई लोग उनके साथ इग्नोर करके चलते हैं, कई लोग उनका सॉल्यूशन ढूंढने की कोशिश करते हैं, लेकिन जो सॉल्यूशन ढूंढते हैं वही फिर आगे एंटरप्रेन्योर की तरफ बढ़ पाते हैं। ठीक। सो सिंपल है कि आइडिएट, इनोवेट और क्रिएट। तो किसी के कुछ क्वेश्चंस हैं वो पूछ सकते हैं, चाहे वो लाइसेंसिंग के बारे में हो, चाहे वो आईपी के बारे में हो।
Oh, anybody has any questions? Sir, I hope nobody has any questions.
ठीक है। तो नेक्स्ट सेशन जो है मैं ही अनाउंस कर देता हूँ। डॉक्टर रवि पांडे का है, मेरे साथ में ही काम करते थे, साथ में ही रहते थे, अभी उन्होंने आईटी जोधपुर ज्वाइन कर लिया है। ठीक है।
Okay, sir.
तो मतलब बहुत कुछ सीखा है मैंने उनसे, है ना। और टेक ट्रांसफर जो पार्ट मिसिंग है मेरे उसमें, मैं बहुत अच्छे से एक्सप्लेन नहीं कर पाया क्योंकि टाइम आपका कांस्टेंट था 40 मिनट्स का। तो टेक ट्रांसफर के सारे की पॉइंट्स जो भी कवर करने हैं वो रवि सर कवर कर लेंगे।
Sure, sir. Thank you, sir.
ठीक है। ठीक, थैंक यू।
Anshu
So
sir, I
we
have one question from you. Anshu sir,
हाँ हाँ प्लीज।
myself, Dr. Pankaj Mishra, I am professor at Amity University.
हम्म
Sir, I wish to know if suppose Amity students wish to connect in IIT Kanpur
हम्म
regarding patent, so you just
फॉर
put
पेटेंट्स और इंक्यूबेशन।
incubations. So
ओके।
can we submit our idea or like this type of activities there?
Yeah, because incubation center at IIT Kanpur is open for all. Anyone can apply, anyone can apply or submit their idea.
Okay, so there is a specific time zone or throughout the year, anytime they can submit.
Throughout the year, depending upon the availability of schemes. So we have page, you can visit or any student can visit. They can check which schemes is what are the schemes available, and their every schemes has their own eligibility criteria. Means ki if you have a specific domain, so you have to select that scheme accordingly.
Okay, so the information is available on the, I think, website.
Yes, sicincubator.com. If you can check sicincubator.com.
That I have seen your PPT also. So that,
Mm-hmm.
okay, thank you very much, sir.
Okay, thank you. So, Swati, you wind up करूं?
yes, sir. Uh, Okay, so we are honored to have with us Dr. Ravi Pandey, who is currently serving as a Deputy Registrar at IIT Jodhpur. Dr. Pandey brings with him extensive expertise in the field of intellectual property rights, legal field, and technology transfer, with a strong background in both academic and administrative leadership. In his role at IIT Jodhpur, he had been instrumental in facilitating the protection and commercialization of innovations, bridging the gap between research outcomes and industry applications. His deep knowledge of IPR framework and technology transfer mechanism makes him the ideal speaker to guide us through the critical subject, which is highly relevant to innovators, researchers, and legal professionals alike. Let us all extend a warm welcome to Dr. Ravi Pandey and look forward to an enlightening and thought provoking sessions ahead. Please, sir.
Thank you, Dr. Swati, for inviting me. I'm thankful to the management of Amity University Gwalior. Equally thankful to Dr. Raghuvanshi for extending the invitation as a resource person and or as a guest speaker. The previous speaker uh, did talk about many aspects of intellectual property right, and wherein the precedence starts with finding a problem statement that has been elaborated by me. I hope I am audible enough.
Yes, sir, you're audible.
So, ma'am, I have a small presentation that I will be sharing with the participants.
Yes,
And
sir.
this presentation basically talks about the nuances of initial IPR filing issues, followed by a critical nuances of technology transfer.
Yes, sir, you can share your PPT, sir.
I hope my screen is visible.
Yes, sir, it is visible, sir. Oh, I hope
So,
everybody can see the PPT.
sorry.
So it is visible, sir.
Okay, thank you. So, as you can see, the title of the talk is Strategies of IP Filing and Technology Transfer. We did some introspection in terms of what are the strategies required. So, as a bachelor students, maybe a BSc student or maybe a BTech student, we may be wondering what is the point of having a patent? Is it just to keep ourselves happy or to add these aspects in our CV, or is there something more to it? So we need to understand what is the logical conclusion of having an IP. So IPR rights are meant to be commercialized. That is the fate of any IPR file, be it patent, design, trademark, or copyright. That is point number one. Be it coming from a UG student or be it coming from a PhD or maybe a layman or even a faculty member having a rich history of research background or maybe having an inclination towards translational research as well. So the main objective remains the same for all IPS. It must get commercialized. There is no other objective of having an IPR. That is point number one. Then what are the strategies of IP filing and technology transfer? If you go to ipindia.gov.in, you will find the entire steps and all the procedures solicited for filing the IP. That is point number two. But where comes these strategies? Does these protocols and the steps portrayed on the website suffice the requirement to fulfill and to establish a full-fledged IP or tech transfer cell within the institution? The answer is no. So IP filing and technology transfer requires multifaceted approach. One is the pipeline. For pipeline, you need a lot of research work. For doing a lot of research work, you would be needing resources like a faculty member, students, research grants, and a ecosystem that promotes such research. Two, we would be needing trained manpower in terms of IP filing and technology transfer. Three, we would be needing a lot of connections with the industry partner in order to translate whatever we have made, whatever we have protected through IP, at the same may be transferred in the form of a maybe intangible or maybe in a tangible form. So both forms are allowed to be filed as an IP. It is a myth among the research community that you need to have a prototype in order to file an IP. So I brought a case study from IIT Kanpur, wherein a lab-based research work was translated into a product. So a portfolio of patents was developed. So let us make it more interactive as possible. So I'm going to share the screen on that aspect. So here what you see on your screen is a product launch of a portable soil testing device. A student may be wondering how difficult it would be to manufacture a product like this. So manufacturing alone is not a difficult task, but making a product is a difficult task. It all started from a MTech thesis work of a student in 2016. Now it ended up in year 2022 as a product. And in between 2016 to 2021, what has happened? I'm going to elaborate all those aspects. So 7 students have graduated. MTech students plus PhD students have graduated doing similar kind of research, that is near infrared spectroscopy, wherein they were trying to find out tangible stuff or maybe a problem solving innovation which utilizes this basic principle of near infrared spectroscopy. So the supervisor, Professor Jayant K. Singh, has identified that this can be turned into identification of soil nutrition within a soil sample. This was a problem for the masses. So the rudimentary technology was initiated for the refinement work. Then the cyclic process of refinement of this product was initiated by the laboratory. The portfolio of patents consisted of 6 patents, wherein multiple inventors got involved. Even gold standards were used from the Council of Agricultural Research, wherein they have been doing research for many decades on soil nutrition, soil quality, soil analysis, analytical segment of soil. Combining all these aspects, the laboratory arrived at a consensus or at a point wherein they found that this is the portfolio which is at a threshold which can be transferred into a technology. Or maybe some industry partner can be approached wherein they can be told that this is at a threshold wherein you can easily adopt it and finally transfer it into a technology, or maybe refine it as a product and sell it into the market. So what we did, we basically approached many industries. So after filing several patents, making a portfolio of patent, writing a lot of research papers, the team was convinced that this can certainly be launched as a product. This can certainly be transferred as a technology. We have enough protection in terms of having an IP portfolio, not only from the patent side, but also from the trademark side, to protect it in case of any imitation or infringement. We approached several industries. If I recall correctly, we sent cold emails and telephonic conversations through our Inventors Connect as well. And we reached out to more than a dozen people. Lot of interactions have happened in between. Several interactions went up to 6 months of time. Several interactions went more than that. Finally, we arrived at a point wherein the technology was transferred to our own incubating company, Agronex Services Private Limited. So again, the problem was the technology was meant for masses, but the company was a startup, which is devoid of resources. So it was almost difficult for a company to mass manufacture it, number one, develop the technology as a product within no time, and three, bring a lot of capital which is required for developing a technology to a product. Not only technology tangible form was required to be converted into a product, but it was also required to advertise, to reach out to people who can be a potential customer, do marketing, advertisement, sales, making a proper team of R&D, manufacturing, and sales. These were the 5 tasks which were in front of the licensee company. So the licensee company has done a wonderful job in developing a product, making a team, and finally launching the product within 7 months or maybe 6 months from the date of licensing the technology. It was a record time taken by the company in launching it as a product. Fortunately, no regulatory hurdles were there in between that has led to this expedited mode of product launch. Now, product launch was made in such a time wherein the pre-booked orders were already given by several customers before the product launch. So the company was utilizing the pre-booked advance amount that the company has charged from the anticipated or prospective customers and reinfuse the same amount in the form of a capital for manufacturing, sourcing the component, raw materials, paying the salary of the employees, and yes, travel expenses and miscellaneous activities as well. So what you see right now is a very beautiful picture of how a product launch look like, but it takes a lot of effort in terms of developing it into a product. So here is the group of researchers working in a laboratory. They are dependent on the team of technology transfer, which acts as a connecting point between the industry. So if we somehow minimize this connecting point of technology transfer team, then what will happen? The inventors do like their technology so much that they are not ready to take the feedback from the industry. And if there are any negative feedbacks, then there are very least chances of having this technology transfer being done. So this connecting point does, they basically make a pointer or maybe a tech brief. They refine the technology, they understand the technology, and only bring those cues which are relevant for the industry. They do not bring a lot of research papers. The team does not work in that aspect, which is immaterial or irrelevant for the industry part. So that's how this is one of the case studies. And currently, this company, Agronex Services, has has done a fundraising up to the tune of around 20 plus CRs. And so far, 600 plus units of this technology has been sold. This product portable soil testing device basically does the analysis of soil nutrition or gives you the analysis of entire soil health report card within 90 seconds. That's not all. I mean, you can get the same results within 90 seconds in your mobile phone as well. So earlier the problem statement was like it used to take a fortnight for doing the soil testing from a laboratory or maybe district soil testing laboratory. And there are higher chances that the sample gets exchanged. So a place of a farmer's field which requires nitrogen gets infused with maybe another nutrition like a potassium. So these exchanges, they do affect the masses in terms of getting inferior yield, inferior product quality, and the losses to farmers and eventually to the GDP of the country, because our country is majorly dependent on agri income. So this is one of the case studies that was initiated in 2016 and was launched as a product in 2022. So 6 years of time took a lot of efforts from the inventor side in developing, from the IP team side in filing the IPRs, then the technology transfer team side in doing the entire transaction, agreement drafting, term sheet preparation, managing all the communication between the inventors and the licensee team. Finally, the licensee itself has taken the most difficult task of developing it as a product and launching, marketing, and generating revenues out of this. So this revenue alone was not uh, 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 profited by the licensee or the startup company. This revenue was shared with the institute as well. So if X percentage of revenue was generated by them, or say X amount of revenue was generated by the licensee company, some Y percentage was shared with the institution as well. And out of the Y, some percentage, or you can say 65% of the revenue was shared with the inventors as well, or among the group of inventors, wherein they themselves have decided how much share needs to be shared among themselves. So this is an entire life cycle of IP, research, eventually leading to a technology transfer and as a product. Next case study that I have, rather than bringing it as a case study, I have a question that I'm going to ask. So are the participants aware about any indigenous technology that is sold in USA but in India? Can we have some answers to this? क्या कोई पार्टिसिपेंट ये बता सकता है कि कोई ऐसी स्वदेशी तकनीक है जो कि अमेरिका में बिक रही है बट इंडिया में नहीं बिक रही है, उत्पाद के फॉर्म में या मे भी तकनीक के फॉर्म में? मैं डॉक्टर स्वाति से आग्रह करूंगा, क्या मैडम आप ये प्रश्न मेरा दोहरा सकती हैं सारे पार्टिसिपेंट्स के साथ?
सॉरी सर।
मैम, मैंने एक प्रश्न पूछा है कि क्या पार्टिसिपेंट्स ये बता सकते हैं कि ऐसी कोई तकनीक है जो कि अमेरिका में बिकती है, जो कि स्वदेशी भारतीय तकनीक है, लेकिन वो तकनीक भारत में नहीं बिकती?
Okay. So anybody has answer to this question? Indigenous technology that is sold in USA, but is there, it is in India also?
Okay, even Google is also allowed.
You can Google it also.
So I'm giving a time of 60 seconds to all the participants. If you could find it out on Google.
Please, all the participants, please participate.
Even you can copy paste the same wording on Google. Let's see what comes out.
Everyone, please participate.
30 more seconds. Any answers? At least tell me what does the Google says. You will have your answer on the next page only. मैम पार्टिसिपेंट्स को हम देख नहीं पा रहे हैं, कितने पार्टिसिपेंट्स हैं?
Sir, there are total 23 participants.
Okay.
Yeah.
So did anyone try to do the Google search?
Anyone has any answer to this question which sir has asked? You have given time for Google search as well.
Okay, let's not waste time. So I'm going to share the screen. So here we have a bovine morphogenetic protein-based BMP responsive reporter osteoblast cell line. So it is a very niche cell line which has been developed by a group of researchers from IIT Kanpur, led by Professor Amitabha Bandyopadhyay in the year 2012. And it was transferred to two companies, Carafast Inc. and one more company in USA, wherein this was specifically used for research purposes only. And since 2012, the institute is getting recurring royalties from each sales of the vial of this cell line. Say the price of this cell line is $925. So when someone gets or purchases this cell line, in lieu of this, this company, Carafast, pays some royalty back to the institution. And out of that royalty, the institution shares the same royalty, shares some amount of royalty to among the inventors. So it is a matter of pride that an indigenous technology is being sold in USA. And since 13 years ago, we have had several news or several information about importing a US based technology. It is a matter of pride when indigenous technology has been transferred to a US based entity wherein for research purposes they are using our indigenous technology. So this is another case study of technology transfer wherein a group of researchers have done something in a specific subset of geography or in a specific jurisdiction of a country, or maybe you can say in an entire country, the application is missing. So what needs to be done, that it is not necessary that for fundamental sciences or for those aspects of invention or research, you will get all the research outcomes which can be protected as a patent. So ऐसा possible नहीं है कि अगर आप पेटेंट फाइल करना चाहें सारी रिसर्च के लिए तो हो जाएगा. सो फंडामेंटल और डिस्कवरी बेस्ड जो रिसर्च है उसके लिए आप पेटेंट नहीं फाइल कर पाए. तो ऐसी रिसर्च को हम लोग ट्रेड सीक्रेट या नो हाउ के फॉर्म में रखते हैं. और उनको सेफ गार्ड कैसे करते हैं? उनको जब ट्रांसफर करते हैं या डिस्क्लोज करते हैं तो एनडीए साइन करते हैं इंडस्ट्रीज के साथ, वेदर वो सेम कंट्री में हो या बाहर हो, और उनके साथ टेक्नोलॉजी ट्रांसफर के एक टेक्नोलॉजी लाइसेंसिंग एग्रीमेंट भी साइन करते हैं एज एंड व्हेन wherein we clearly say that the breach of confidential information cannot be compensated just by mere monetary compensation. So it eventually becomes a offense, or you can say offense of breach of trust. So outlining all these aspects of doing a technology transfer by having a proper non-disclosure agreement, by having a proper technology licensing agreement, we eventually sign an agreement and eventually license a technology. So let us understand what are the aspects that we need to see, or you can say foresee, after if I am a researcher, say I am a MSc or a MTech researcher, say I am a PhD researcher, what options do I have? So the three options that are there for the researchers are: do your fundamental research. You can publish several research papers. It will not be correct to say research paper with no reproducibility factor, but majority of the research papers do not have the reproducibility factors. Even I am claiming about well-known journals like Cell and Nature, where the non-reproducibility factor is up to 60%. That is option number one. The option number two is to do technology transfer to companies. You have already seen two case studies. One was about having an invention wherein recurring development was done for several years, say 6 years. A portfolio of patents was developed. The other case study did talk about invention, or you can say a research outcome where it is devoid of any patent. So the option number two is to technology transfer or license to companies. Then option number three is to do faculty or student entrepreneurship. Under the National Innovation and Startup Policy 2019, students studying their BSc, MSc, BTech, MTech, PhD work, or any of the even liberal arts or fine arts coursework, they can simultaneously go ahead for startup incorporation and operations of a company. Similarly, the same policy NISP 2019 provides a privilege to faculty members. So along with their job position, they can incorporate a startup company and facilitate this translational side by solving a problem. So these are the three options available for students and faculty members. We need to basically understand what problem statement we have identified, what solution we have got so far, and what suits our current situation. I'm into fundamental research. I immediately would like to transition from fundamental research into applied research. At PhD level, that may be a possibility, but being a full-fledged researcher or maybe a faculty member, that may be a very difficult task to do. That is my understanding. But we'll have to understand which option suits me right now. But just being a faculty member in the fundamental research does not mean that we cannot go ahead to technology transfer or faculty entrepreneurship policy. We will always have the option to that. And interdisciplinary research has recently become a hotcake in several academic organizations. So we can certainly opt those avenues as well. So here I have a IPR management flow chart in an academic institution. So basically we have a IPR cell and / or a TTO. Basically it is a combination of IPR cell and TTO, but if you go to top organizations like IITs, ICERs, ISC, and some other private organizations, you will find these entities in the same building, but functioning in a separate manner. IPR cell and technology transfer are complementary to each other. It is not possible that you separate both of them and get the desired outcome. So how the IPR cell works is basically by doing an in-house filing or by doing some impaneled attorney or outsourcing the work. So these are the two aspects through which a IPR cell works. Now, what are the aspects required to have a functional, or you can say a successful, or the strategy behind a successful IPR policy is to have policy, number one, that we already have as per the IPR policy, National IPR Policy 2016, which is applicable to all the academic institutions. Second is the funding. Some budget head needs to be devoted towards the IPR policy in terms of hiring manpower, in terms of paying to the empaneled attorneys as a professional fees, or maybe the payment in terms of having an official filing fee for the patent application, design, trademark, or copyright file. And third is the most important, that is having a professional, dedicated, and trained manpower. Without trained manpower, this ecosystem cannot sustain for last. And the final thing is, ecosystem never changes overnight. I go to more than 50 institutions in a year for giving lectures or sharing my insights about all these 15 years, what I have understood from this technology transfer or IPR. People would like to transition or transform the entire ecosystem within a matter of overnight. So that does not happen. It takes at least couple of years in transitioning. And you need to understand, just by having a proper infrastructure, you cannot change the ecosystem. You need to bring a pipeline that starts from the research work. You need to establish a full-fledged IPR cell and technology transfer office. And just by giving an alternative option to a senior dean or to a senior director and making him or her as the in charge of IPR and technology transfer, these things do not work. You need to hire people who have understanding of IPR filing, who have some understanding, and their dedicated work involves IPR filing and technology transfer. These things have been understood by the national ranking framework as well. The NIRF ranking gives a weightage of up to 35% for the NIRF innovation segment, wherein this 35% weightage is given for IPR and technology transfer activities in an academic institution. So you can understand it is a recurring, or you can say it is a cycle wherein you are feeding the research work and feeding the IPR cell, which is getting translated into your national rankings, and eventually on these ranking frameworks, lot of research grants, lot of inflow of quality students, quality faculty members, quality staff do depend. So it is a cycle wherein we need to infuse manpower, fund, and policy. A lot has been mentioned about research paper versus versus patent. I would not go much into detail on that, but we need to understand that we cannot file patents for all the inventions. There may be some discovery or there may be some invention which is non-patentable. For example, a perpetual motion machine, which is defying scientific laws. So all these aspects of non-patentability are clearly mentioned in the section 3 of the Indian Patent Act. If you are working or transitioning towards a translational side of work, or you are trying to open or incorporate a startup company with some invention and with an objective or an endeavor to have a product in the next 12 months from the engineering side. So it is advisable to understand these aspects as well. Just by being an unprotected means, if you are going into the market, there are higher chances that people or companies would try to imitate your product and would try to infringe upon your invention. So the options are two. One, to file the patent. Second, if it is not patentable, keep it as a secret in the form of a trade secret. You have an idea what next? Why IPR and technology transfer? This has already been discussed in detail in the previous slides, but still I would share it that the revenue generation through licensing agreements and royalties, these add up to taxes. Government makes GST, government makes taxes, livelihood from these technology transfer do happen. Companies do hire people to promote the product into the market for the sales, marketing, and research work and manufacturing. It is a cycle wherein the revenue received from these royalties, or maybe you can say from the technology transfer, gets reinfused in the research and development. So more and more technology comes out in the future as well. So what you are feeding today will eventually become a product tomorrow. It enhances the academic reputation and promotes the collaboration between academia and industry. There are some salient features of technology transfer IPR filing. We need to understand that balance of academic load without any concern about entrepreneurship. Issues like regulatory, manufacturing, marketing, finance to be taken care by licensee only. Automatic income generation through royalties and upfront licensing fee. So for example, if I'm a faculty member, I do not want to open a startup company. I think these compliances, regulatory, running a company will be a burden on me. My better option would be that rather than making or going till the product phase, it is better to transfer the technology to some other company, let them handle this part. I cannot be a master of all. This is a circle of, or you can say the process flow of technology transfer. Whether it is India, whether it is USA, any IIT, Stanford, Cornell, the circle remains the same. You do some research, you protect your IP. In the absence of IP protection, we do make it as a trade secret, or you can say as a black box. We market it to companies. We make tech briefs. We upload them on social media websites. We send cold emails, cold calls. Co-inventors connect. We send it to industries. We let them know this is what has been developed so far. Many times it happens that the management of industries are ignorant about some innovative developments. So these pipelines needs to reach out to industry partners, then only this can proliferate into a product or maybe multiple products. During the conversation, we need to protect our interest as well. If you disclose everything, the industry would not come back. So you need to sign an NDA with the industry partner, then only do the confidential disclosure. After having a consensus about or further receiving further interest, we can do a valuation of the technology. We can do a proposal in the form of a term sheet. Upon having a consensus on the term sheet or the licensing terms and condition, we can transition to an agreement phase, draft agreement sharing, and finally, upon having a signing on the dotted lines, we can go ahead and initiate the technology transfer. So we need to understand that licensing or through an agreement does not mean the technology transfer has been done. So technology transfer gets done only after the licensing, or maybe in the case that the technology is very much open, wherein the rights are there with the licensor, So in that case, the manufacturer or the licensee knows uh, how to convert this technology into a product. So technology transfer may not be required, but in that case, technology license would still be required. So this is the entire chakra, or you can say chakra view of process flow of technology transfer. Lot of efforts are required from the inventor side, from the IP tech transfer team side, and from the licensee side. Without the combination and the effort by all the three entities, it is not possible to have a full-fledged technology transfer. This aspect, licensor, licensee, I have already discussed about. Entrepreneurship is why entrepreneurship. If I do not want to go ahead in the technology transfer domain, I would like to turn my research into a practical application. How do I do it? I can incorporate a startup company, maybe a private limited company, which gets incorporated within a time frame of 7 to 10 days. And afterwards, I can hire some staff. I can outsource the manufacturing in case the resources are restricted and the startup company is deprived of those resources or having a full-fledged assembly line in terms of doing the manufacturing. So it is always advisable to outsource such type of manufacturing work and not to invest a lot of money or capital in terms of initiating such translational side of the product development or the product manufacturing. What are the benefits? It eventually creates jobs, and economic impact for startup is certainly visible. We are number one in terms of the number of startups, and collaboration between academia and industry also enhances. Some faculty run startup companies that I have identified, I'm going to share it with you. Right now, the number one startup company in the country in terms of drone manufacturing, wherein the 80% parts of the components of the drone are indigenous. It was run by a group of faculty members. Last time it was valued at 55 crore. It is almost clear to 100 crore valuation. 80% of the components, if we leave aside the chip and uh, the battery component, majority of the components are either in-house manufactured or in-house sourced or indigenous only. So this is one of the successful companies that we had. The second is the Checo company. Again, it was a indigenous company. All these aspects are in-house only. A portfolio of patents of around 3 patents was developed, wherein not only licensing, but in addition to licensing, the startup founder or the faculty member himself decided to translate it into a product. So he himself, along with the licensee, he tried to sell it into the market openly. Currently, the customers are Amazon and other e-cart websites, which you can clearly see and how this translation is happening. That's all from my side in terms of having strategies for technology transfer and IPR. In case of any queries, I'm open for any questions in case participants do have. Dr. Swati, could you please facilitate the questions? Swati, you are on mute. Hello.
Thank you so much, sir. So give
I
me a
hope I finished it exactly on time. My time was 11:30. So considering the Q&A session, I think I'll be
yes,
finishing
sir.
the same within no time. Do we have some questions, Swati? You're on mute.
Thank you so much, sir, for your enriching, insightful lecture on IPR. And now we are waiting for our next guest, Dr. Rams. Give me a minute. Anybody has question, they can ask. Anybody has any question? Sir, I don't think so. Anybody has question?
Thank you, ma'am. Thank you.
Thank you. Thank you, sir. Thank you so much. Let's wait for our next guest. Give me 2-3 minutes. I'll connect with the next guest. Okay, shall we start? Shall I start with your introduction? Okay, okay. Yes, yes, sir. You can join. Okay, okay. पढ़ेंगे थोड़ा टाइम दो सारे बच्चे कहाँ चले गए मैंने बाहर जाने के लिए थोड़ी बोला था
Hello,
Yes, sir. Yes, sir. You're
is
audible.
this audible?
Yes, sir. You're audible.
Yeah, thank you. Thank you so much.
Okay. So we are honored to have with us Dr. Varun Bajaj. He's an associate professor at Maulana Azad National Institute of Technology, Bhopal. Mr. Bajaj is a distinguished academician and researcher, widely recognized for his expertise in the field of engineering, innovation, technology-driven solutions. His contributions in both teaching and research have made a significant impact on students, scholars, and the wide academic community. We are delighted to have him with us today, and we look forward to gain valuable insights through this lecture. Uh, please, sir,
Yeah,
let's
thank you, Swati,
Thank
for
you.
introduction. Yeah, please give permission for presentation.
Yes, sir, you can.
Yeah, like for sharing. Just is this visible?
Yes, sir, it is visible.
It's moving.
Yes, sir, it's moving, so it's visible.
Yeah. So, first of all, yeah, thank you, Swati, for this introduction. And yeah, I would like to thanks Dr. Prateek for inviting me this workshop. So this workshop is 2 days workshop is sponsored by MPCST. So thanks to MPCST for giving this opportunity to Amity University. And the workshop is intellectual property rights and challenge and opportunities. Okay. So one quote I would like to tell you, the teachers open the door, but you must enter by yourself. So in this workshop, you will get many lectures and many things about the IPR. But the thing is, if you do, then understand the process. Okay. If you are just looking, you are just listening the persons how to do IPR. But if you do the IPR, then you will understand the many things. Okay, so you have to file the ITR, then you will understand whole process. So just we can, yeah, I can give you the guidance, I can give you the direction. But when you will enter, when you will do the IPR, then only you will understand the many things. Okay, it will give you the good experience. Okay. So with this quote, I would like to start my presentation, yeah, or discussion on this topic. So the question is why we need IPR. The first question is why we need IPR. If you are not looking for the money, then this lecture is not for you. Okay, because IPR means you want to earn or you want to grow yourself as a businessman. Okay, you want to earn the money. Clear? So that is the main motive of the IPR. If you don't want to earn, if you don't want to technology transfer and other things, then what is the need of IPR? So simply if we are looking for the huge amount of money, then we required IPR. Okay. So that is the main motive. So what is these are the type of properties. So like real properties, personal property and intellectual properties. Okay. So real properties is unmovable, and personal property, which you can move. So these are the personal property. And if you talk about the intellectual property, so intellectual property, you can understand this way. The things we are creating from or originating from your idea is originating from your brain. That is your personal uh, uh, properties. These are now intellectual property, which is coming from your brain. The idea you have generated from your brain with your education, knowledge, and experience, that is your intellectual property. Clear? So if you think that at a time, if two persons is solving a one problem, then they may have a different ideas. Clear? They they have a different method, they have a different process to solve any problem. Clear? So IPR means that is coming from the intellectual property. Intellectual means from inner of your brain, that idea has been created, solution has been created. Clear? So these come under the intellectual properties. That is your properties now. Clear? So when you are talking about the process, so environment is the most important part. So like what innovation you have done, what new product or services you have created. Clear? Whether it is product or whether it is services. So that is known as environment. Input means what will be the application, who will be the applicant, who will be the funding agency. Well, if you are employee, then you have to file that patent with, you will be inventor, clear, applicant, and your institute will be inventor. So why we need to involve the institute? Clear? That is a big question. So you will be applicant, but the experiment and the resources you are using, if you are developing some uh, uh, product, so if you are taking help of the institute, then you have the institute will be inventor and you will be the applicant. Clear? Because you are the employee of that institute. So if you will become inventor, then the same time you are employee. So institute can claim that you have used the resources. So when you are doing any IPR, so the inventor concept should be clear. Who will be the applicant and who will be the inventor? If you are not using any of the resources of institute, then you may inventor and applicant. So depend on the condition or two condition, it depend on the what should be the process in your institute. So based on that, you need to bifurcate who will be the inventor and who will be the applicant. Clear? So here the ethics has came in the picture. Clear? Ethics means suppose you are using the lab of your institute, then alone you cannot go for the as a applicant. Okay, you have to involve your institute as a inventor. Clear? Now, funding. So for this particular IPR that you are going to file, who has funded you? So if you are having a fund, then clearly you have to mention the sharing of that IPR. If it is generate some profit, or if you are going to transfer this particular patent, then how the bifurcation means, how much institute will get, how much funding agency will get, that you need to bifurcate. Clear? Otherwise, if you go for IPR, then if it is earn or your IPR will be transfer in the technology, then this type of problem will be occur. So initially you have to everything you need to identify it. Clear? Suppose for if you are filing IPR and your institute has supporting for funding, then you should not be inventor. Okay, because the whole money has been invested by your institute, then institute will be inventor and you should be applicant. Clear? So these all things will come under the laws and regulation of the IPR. Clear? Or these are the administration IP agendas. When you talk about the process, so process you have a examination. Clear? So before examination, if in your institute you have to either you can also file the patent, but the problem when you are going to file the patent, then you have to check the patentability. Clear? So if your institute has hiring some agencies, so agencies means they will have a group of persons, so they will help you to find out the patentability report. They will suggest you whether your the IPR is patentable, what you can claim, what are the claim are correct, and if this claim can be improved, then they will give you the idea. How you can write your patent, so it will be you can have a your claim should be justified. Clear? If you don't have, then you have to yourself you have to go for find out the patentability of your IPR. Clear? Because if you are not able to find out the patentability of your IPR, then it is a in India it will take too much time. Clear? When you are for grant, it will take near around 4 to 6 years, or sometime it is 3 years, but it will take more than 3 years. Clear? And you have filed the IPR. Clear? After that, after the review has came and you are not able to justify that reviews. Clear? Then, or your idea is not patentable, then whole process will be destroyed. And the hardcore money of your institute is also wasted. So before that, before examination, you need to check the patentability. So 90% confidence interval, you can, if it is patentable, then based on the 95% or 90% confidence interval, you can go for the IPR filing based on the patentability report. Appeal means suppose you are getting some review, then based on that review, you can justify yourself. Clear? Then it will go for the publication, what type of IPR you are filing. Then these processes will be based on the policy making. So all institute now they have a make a policy for IPR. So you have to follow that policy of for filing this process. Clear? Output. So output may be in the form of patent grant, trademark registration, or you can go for the technology transfer. Clear? If you go for the impact of IPR, so there are only two impact. One is the economical growth and development. Second one is the advancing of the science and technology. Clear? So now for like suppose you are going for the advancement of science and technology, then the publication is also more than sufficient. Don't go for IPR. If you don't have a if you don't want to create some technology transfer and you don't want to start your startup, then don't go for IPR. Clear? If you are going economically, if you want to become strong, then go for IPR. Clear? So if you talk about the type of IPR, so like trademarks, so these are the names or logo. Business process means these are the trade secrets. If you are going for technology, you are going to develop some technology, then you can go for the patent. If you are designing some product, then you can go for the design. And if you have some marketing software or some product brochures, then you can go for the copyright. So these are the bifurcation of intellectual property rights. So one by one we can understand what are these. So like if you are if you are talking about the trademark, so every day you have seen many words, name, symbol, devices. So these all come under the trademarks. Goods and identifying these goods and services, these are known as trademarks. Clear? So they may be logo, they may be banner, sometimes it is sound and smelling also. Like these are the few examples of trademarks. So like word marks. Word marks means the name of the company, like Agnihotri and Jhai Associates. It may be sometimes you have seen Mehta and Sons. So these are the word marks. Clear? If you talk about the device mark or logo, so every institute like we have a logos. Clear? So these are known as trademarks. Logos is also a trademarks. So sound marks means like Nokia tone, window tone, Parle-G tone. So these are the sound marks because they have taken a trademarks. They have taken a patent for the 10 years. Clear? So like classification marks like ISI mark. Sometime it is collective marks like CA association. They have make some marks. So some association have some sign. Then this marks is known as collective marks. Color, sometimes color is also fixed like Barbie. They have a pink color. So they have this is the trademarks of the Barbie. Sometimes Cadbury they have a blue color. So these are also color based marks. If you talk about the trade secrets, so trade secrets may be some formula, patent, or some program, device, method. So these come under the trade secret. Trade secret means the hidden things like Coca-Cola. So Coca-Cola, what they are doing, they have a two different type of mixtures. They are the amount of these two different type of drink they are mixing, then they are making Coca-Cola. But they are not given any formula for that. Clear? So that's why the Coca-Cola they have a different test and they are not going to reveal that secret. So they like KFC also they have some trade secrets. Okay, like Domino's, you can find out the pizza many places, but Domino's they have a different test because they have some trade secrets. So that formula they are not going to reveal. The pattern they are not going to reveal. So these are known as trade secrets. If you talk about the copyright, so all publications come under the copyrights. Clear? So if you have a original work in the authorship, so they all come under the copyrights. Clear? So for example, copyrights, they have two-way copyrights. Two-way copyrights means you cannot copy of the other content, and if you have published that content, then some other person also not copy that content. So that is known as copyright. Copyright means you cannot copy anything from the others, and if you have published it, then you have to sign the two-way copyright. So two-way copyright means you have not copied with the other persons, and your work also not copied by the third party. Clear? So these come under the copyright. So copyright existence, when your work is published, then you have to fill the copyright form. Suppose you have published some paper, some conference paper, journal paper, thesis you have published, then you have to sign the copyright agreement. Clear? So for dramatic work also you can go for the copyright, musical work, cinematography, sound recording, photographic work, and architectural work also you can go for the copyrights. Clear? Some thesis you have write, then some codes you have write. So these things you can go for the copyright. Clear? So what is the difference between the copyright if you are publishing book and if you are publishing paper? Then these two are different things, because when you are publishing paper, that time you are transferring the copyright to the publisher. Clear? And there is no money has involved when you are publishing. So what you are doing, you are copywriting or you are transferring all the rights to the publisher. Clear? So somebody using that data, then you cannot claim earning from that data. Clear? Suppose you have published some paper in IEEE transaction or some conference paper in IEEE. Clear? So in this copyright, you will not get money. But the publisher, if somebody is downloading that particular article, then the publisher will get money. Clear? So these are the conditions of copyright. But in case of book, it is different. In case of book, based on the condition, you are eligible for royalty. Sometime it may be 15%, 20%, depend on the publisher. Clear? So that time in this particular copyright, the money has involved, because suppose somebody is using your book and they are taking that book, then you will get a royalty. So copyright, some parts you can earn the money based on the royalty. Clear? But if it is depend on the copyright, what type of copyright you have signed. But most of the cases, in the publication, most of the cases in a copyright, you are transferring your rights. Clear? But in case of book, you are not transferring the rights so that you can earn the money based on your royalty. Clear? So this is the difference. So if you are publishing a book, then you, even though image also you cannot take from the some other place, because the royalty has involved. So when you are writing the book chapters, then you cannot, even though by referencing also you cannot take the image, because the royalty has been involved. But if you are in the journal, if you are going for the journal publication where the royalty has not involved, that time you can take that image and you can cite that image from where you have taken. Clear? So that is the difference in the copyright, in the book copyright and the paper and publication copyrights. Why we need copyrights? So copyrights is the one document. Clear? Suppose you have written something in your diary, clear, but you don't have copyright. So, and some other person also copied that thing. Then you have to prove that thing in the court. Clear? But if you have a copyright and somebody has copied, so immediately you can tell that in this particular date, you have filed the copyright, then nobody can copy your work. Clear? So that's why we required copyright certificate, so that just you will show the copyright certificate, then you can prove that the work is published by you and you have honor of that particular publications. Clear? So most of the publications, this copyright is required. Clear? Now, patent. If you talk about the patent, so patent means to lay open. Its meaning is to lay open. It's a Latin words. So most of the cases, if you have a new problem and new solution, then you can go for the patent. Clear? But in case of publication, if you have a new problem and if you have an old solution, then also possible. But in case of publications, if you have an old problem and you have a new solution as well as the old solution, clear, then also you cannot go for patent. Clear? So if you have a new problem and new solution, only you can go for patent. But for publication, you have a new problem. If you have old solution, then also you can go for publication. Clear? So what I can say you, incremental work is not patentable. Clear? If you have an old problem and you are saying that some increment, some accuracy you have improved, sensitivity you have improved, so that is not patentable. Clear? For patent, your problem should be new and solution also new. Then only you can go for patent. So for patent, you require three things. One is the novelty. Second one is the non-obviousness, which is inventive steps. And third is industrial applicability. Industrial applicability means the patent should be scalable. The patent you are doing, so the product should be scalable. It can be used by the some. It does not have a barrier of the community. Means it should not be fixed for the some reason. That particular thing is applicable for this particular reason. So it should have a industrial applicability. So these are the three things. If your device or your process have these three things, novelty, inventive step, and industrial applicability, then you can go for the patent. So patent we required like source of recognition of for inventor, incentive to develop a commercial product. What you will get if you are going for patent, so these are the things you will get: license to an existing company, or you can start your new company. So like if you got some patent, then what you can do, you can contact to the some company to commercialization purpose, or you can also start your startup. So these are the two things, or you can get some incentive in for commercializing this product. So like suppose you have a IPR. After that, you want to transfer this IPR to some other company. Then you have to go sign some agreement. Then you can find out the how much money you will get, how much money company will get. So these process you need to do. Protect against the imitators. Protect against the imitators means, suppose you have come up with some solutions, clear, and some other person also have a same solution. So depend on your filing date, then you can prove that you have solved this problem. Clear? Then the patent have the attribute to personal property, like you can sold, you can mortgage, you can go for the licensing, you can assign third party. Clear? Then based on that, you can protect your patents. Now, can I patent everything? No. You can have, suppose you have some idea or concept, so that is not patentable. Clear? Some pure mathematical formulation, some phenomena of natures are not patentable. Suppose there is some word sound that you want to go for patent, that you are not patentable, because that is the phenomena of nature. Suppose you want to patent some C, sound of C, you cannot patent, because these are the phenomena of nature. So these are not patentable things. Some mathematical formulation, these are not patentable. So what we can patent? So patent, you can patent some new process, useful process. You can patent some machine, some manufacturing composites you can patent. Clear? You can patent some business methods. You can patent some softwares. Clear? So the things which is already exist in the environment, that is not patentable. Clear? So patentable things that should be created by you. Either you can go for the design patent. If you have designed something, then it is patentable. But as I already told, IPR, so the two persons cannot think in the same way. Clear? It's a very rare. It's a very rare. Even though if you have a problem, then two persons are thinking for the same problem, then they may have different solutions. They cannot have a same solution. The solution will be different. Clear? So if the solution is different, then only you can go for the patent. Clear? If you have a similar thing, same thing, then you cannot go. Clear? And even though person having a same problem, then they have a different solution, also patentable. But incremental work is not patentable. Incremental work means, suppose you are going to find out some diagnostic method and you are saying that your method has improved the accuracy of 2%. That is not patentable. Clear? If you are come up with the new solutions means you are not taking help of the other person. You are not quoted some literature, then it is patentable. Clear? So that initially you have to identify whether it is, and the person easily understand whether it is your property or you have created this thing or you are borrowing from some other place. So 90% problem you will solve if you think yourself whether it is created by you or by the you are taking from the some other place. Then 90% patentability you can check yourself. 10% patentability has been checked by the other person by some methods. Maybe the invention is already has been done or the some process is already invented. So for that you required patentability check. But 90% you can yourself judge yourself whether it is your property or not. Clear? So 90% problem you can yourself solve. So now these are the few things I have listed here, like plant, animal, or whole plant and animal, or any part of the plants and animal is not patentable. So few things like arrangement or rearrangement of the device is not patentable. Clear? Topographical of integrated circuit is not patentable. Clear? Agriculture method is not patentable. So these few things I have already mentioned here, which is not patentable. Clear? Now, so like already discussed, what is patentable? So exactly if you have these three things: novelty, non-obviousness, and utility. Novelty means the machine manufacturing process, composite matters must not has been previously described and known. Previously, there is no phenomena of that. Then it is novelty. Clear? So, like most in case of publication, when you are going for the publishing some papers, clear? So in publication, you are going for the incremental work. Incremental means you have to go for the literature, then you have find out what has been done, what has not been done. Then you can do something in that so that your result will improve. So that is the publication. But if you are going for patent, then this is not required. Patent means the novelty is the main functioning of main thing is in the patentability. Clear? So if something is already described, already published, then it is not patentable. So if you are thinking for some patent, then don't go for publication. If it is published, then you cannot go for patent. Clear? So if you are PhD student and you are thinking for IPR, then first you file the IPR. If it is published, then you can go for then you can write papers for that publication. First file the IPR, then go for publication. If you publish paper, then the IPR is not possible on this. Clear? So the concept should be clear. Utility means the invention must be function as intended. You have an idea. So that idea should be implemented. If you have a concept and idea, then idea it is not patentable. You can go for the patent pre-processing, pre-patent filing you can go, but in a year, you have to create that idea in the roadmap you have to create and you have to develop that product within 12 months. Clear? So pre-patent is possible. Pre-patent possible means suppose I have some idea and that idea I want to file. But within 12 months, I have to make that product. If I am not able to make that product, then IPR will be failed. Clear? So idea is not patentable. You have to create that idea. You have to develop that idea. Clear? Either in the form of software or hardware. Non-obviousness means a patent requirement that ensure that the idea is new. Clear? So when to file the patent, so date against when the invention will be tested or novelty and non-obviousness by the patent examiner. Clear? That time you have to, that non-obviousness you have to show. Novelty you have to show. So that is date of filing. That is most important when you have filed so suppose you have idea, so provisionally application you can fill. Then you have to ensure within the 12 month, you have to complete that patent application. Hope you have understood. What you can do, suppose you have idea. From this way, you can solve some new problems. Clear? So what you can do, you can provisionally application you can fill. So which will secure your filing date. Clear? Then within the 12 month, you have to you have a time to experiment. You can develop your device. Then after that, you can file the complete application. Okay, so based on the provisional application, you can secure your filing date. Clear? Complete after 12 months, you have to complete. Clear? So suppose you have some idea, so you can provisionally you can file the application, but within, if your idea in such a way, so 12 months you have to do all experiments. Clear? Testing of your technology, these things you have to do within the 12 months. Clear? So what we do, if you have get some result in a simulation, clear, or some software, how your method is working. Clear? So some prior result you have, some prior experimental result if you have, then what you can do, provisional application you can file. Then the 12 month you have to complete everything, you have to develop the device, then what you need to claim it, then 12 months you can complete your application. Clear? So this process is very important to understand. So if you have done this, then you can secure your filing date. Clear? So why this required? Sometime the new problem has came in the market. Clear? Then you need who will file the first. So what people do, suppose new problem has come in the market, then you have some tentative solution. Clear? Then provisionally application you can secure your date so that you can have a some other person does not means like they cannot claim that ki they are going to solve this problem. Clear? So that is most important part. So process, this is the process. So once you have a filing application date, once you have filed the patent, then it will take 18 months to 1 month to publish it. And previously it was 18 months. But if you submit some forms, publication forms, then within 1 month it will be published. Then you can file forms 13 for expedite the examination process. Then examiner will have some objections. Then you can again you can file the objections. Then again examiner will check. Then it will reply your objections. Then there is some hearing. They will hear you when you will file the objection of these reply of objections. Then either it will be rejected or it will be granted. So this is the simple process. So the every time you have to pay some money, like if you have filed the filing process, you require to pay some amount of money. Then for publication, if you expedite this publication, if you want to publish in 1 month, then you have to pay some money for early publication. So early publication within 1 month. Otherwise, usual application will take 18 months. Then expedite the examination process. Also, you have to submit some form 13. Then form 13 or form 18. Then it will go for expedite the examination process. So it will reduce the time of grant of your publications. Clear? If you are going for the law, like if you are not submitting the form and you are not submitting, if you are going for the routine process, then it will take 14 months for examination, 48 months for examination. Clear? It's a routine examination process. If you are expediting process, then it will take 12 to 24 months for examination. Clear? After filing of India, once your patent has been filed in India, then there is a PCT member, which is known as Patent Cooperation Treaty. So 158 countries you can file your patent, like US, China, Europe, Australia. So we have this PCT application. So PCT application means the countries are the member of this PCT. Okay, then after 12 months or within 12 months, once you have filed in India, within 12 months, you can file in the PCT countries, or which does not require filing permission, but non-PCT countries, you need to take a filing permission. Then you can file the patent for the non-PCT country. So filing permission you have to take from the patent office. If it is PCT member, then directly you can file the patent for the some other countries. So these are the patent requirements. So like you required abstract, background of invention, you required summary of invention, figure with brief description, a specification is required. So the invention you have done, so fully disclosures you required, how you have made, what you have used, everything you required. And claim, so claim they be independent or dependent. So the legal boundary of the protection you need to find out. Clear? So like in a claim, so the legal opinion you required when you are going for the some claim. Clear? So sometimes you have to go for the partial claims also. Then this claim you need to identify. So you need to fill whether it is independent claim or non-independent claim. So based on that, you can make your patent document. Clear? So when we talk about the patentability search, so if you need to identify whether your patent is novel or not. So there are two different databases. Some are the free patent databases which are listed in this left hand side, like Google Patent, US PITO, Web Patent Database. So these are the free databases. Clear? And some are the paid patent databases. So like Drovent, PatBase. So these are the paid patent databases. Clear? So when you are going for the patentability search, clear? So suppose I have I need to go for patent. Clear? So I can only search the patentability in a free website. Clear? These are, I have listed here. These are the free websites. Only the patent are available. These are the free databases. Clear? So I can find the patentability only from these databases. Clear? But if your institute has or you has taken help of the some of the companies, they already have a paid database, they already available. So they will search from the entire databases. Either they are free or paid. So you will have a exact patentability report with you. Then you can go for the what type of claim you can go and what type of claim you need to modify. Clear? So that you need to do. Clear? So patent, when you are filing the patent, then patentability search is very important. Based on that, you can have a clear cut picture whether your patent is patentable or not. Clear? So sometimes you have to take help from the some other companies, like these are the IPR companies. So they are helping people to find out whether it is patentable or not. They will help you how you can modify your patent so that you can go for the some claim. Clear? Another is landscape analysis. Landscape analysis means you need to identify what others are doing in the technology domain. Clear? Whether this, what type of solutions are available in this particular problem, what are the existing technologies are available, what are the other players are working on this area. So that analysis you have to do. Clear? Okay. You need to collaborate with the some other persons. Like suppose I have developed some device for non-invasive diagnosis of thyroid. Clear? Till now, all methods are invasive for diagnosis of thyroid. Clear? So suppose I have invented one method where non-invasively I can identify or diagnose the thyroid. Clear? Then what should I do? First, I will find out based on, suppose I have developed some method. Based on that, what I will do, I will find out whether it is patentable or not. What type of non-invasive methods are already patent? What type of device are available in the market to identify thyroid? Whether the non-invasive methods are available or not, some device are available or not. Once I have not find out anything, clear? Invasive methods are available, but non-invasive methods are not available for finding out the thyroid. Clear? Then what I can do, either I can go for the alone patent filing, or what I can do, I can collaborate with some company. Okay. And I will discuss with them. I have this idea and I have, these are the result I have. Then I can go for MSME. Then I will discuss with my idea to MSME. Then mutually both will sign the agreement. Then we can go for the patent filing. So both will be the partner. So before that, we have to sign some agreement. Clear? Then both can file the patent. So it will expedite the process. If you are going alone with your, like if you are going, because the company MSME, what MSME will do, MSME will find out whether the solution you are making, that product is marketable or commercializable or not. Otherwise, they will not, MSME will not take interest. Clear? Another thing, what I can do, I can go for the alone. That time I have to do everything. I have to go for patent search. I have to go for the landscape analysis. Everything I have to do. Then I have to decide. I will go alone with the patent. Then that time, after getting patent, I can start my startup, or I can mortgage my idea. I can give licensing to some other company for commercialization purpose. So these are the two things that you need to identify, ki whether your idea have a potential or some companies are interested on that idea. Then both can go for the filing the patent, and you can alone you can go. If you are going with the some company, then what benefit you will get? They will sponsor you, they will give you the fund, or you can, and the company also find out whether this product have a potential of commercialization or not. Clear? So they will help you on it. Clear? Otherwise, you can alone also, you can find out the patent. So these are the two ways the people are doing this. Okay? Informant analysis, like company and enforce pattern, like licensing opportunity you have, like a player using your technology, what type of players are available in the market or companies are available in the market who will take this patent. Clearance analysis, like sometimes suppose I am doing some experiment in human body. Suppose like I told you thyroid analysis. Then I have to take ethical clearance from the some hospital or our ethical committee. Clear? If you are doing some experiment on it, human experiment, animal experiment you are doing, then you have to take ethical clearance for that. Then it will find out whether the patent is valid or not. So sometimes clearance is also required, depend on the problem. Royalty and sale. So these are the limited risk. Like if your design is very expensive, manufacturing product is very expensive, so you cannot develop your own product. Clear? So it is very high risk, high level of risk. So patent licensing is required. So you have to collaborate with the third party for commercialization purpose, because you have developed the product which having a cost is in crores. Then you required some investor for that. So if your product having a less expensive, then somebody can give you the fund, or you can also sponsor yourself. But if your product or design having a high cost, very expensive, then you cannot develop your own product, you cannot start your startup. Then you have to find out, you have to transfer the risk to another party, like company. Then company will see whether your product having a scalability or not. So these are the things that these come under the royalty and sales. What are the benefits of your, like if you file the patent, so what is the benefit of your institute? Clear? It will improve the NIRF ranking, you will get recognition, increase the financial health. Like some of the private institute, they are given an incentive in the, suppose some faculty has filed the patent, then they are given an incentive of it, they are given increments, they are increasing the salary of the salary of the particular person. So these are the few advantages. And your institute, what is your institute will get, your institute rank will increase, your institute funding will increase. Clear? And some research project you will get. So like licensing opportunity, better placement prospectus. So these are the few benefits of your company when you are going to file the IPR. Now technology transfer. So technology transfer, we have a different TRL levels. So like basic research, you have started your student, BTech student, MTech student, they have started some basic research. Then the technology applications, then feasibility of demonstration, Then lab scale development. These are the level 4. Then technology development. So up to TRL level 5, everybody is like in your lab, up to TRL level, you can go for the up to level 5. But if you go beyond .8, then you require viability demonstration, like your device is like how much area, means you have to check all the output, all the pros and cons of your device. Clear? Then you can go for the commercial transition. Commercial transition means if your product is ready, then you can contact to the some company. Okay, or once your product is ready, then you can directly file the patent, or you can go for the commercialized transition, or you can go for the commercialized demonstration. Then commercial development you have to start. Clear? So these are the different TRL level. So up to if you have completed TRL level 9, then your product is ready. Clear? All level you have crossed, then you can go for the technology transfer. Clear? So these are the different levels. So you need to identify your product and your idea, which level it is. Then accordingly you have to do. So like if your technology has been developed, then you can go for the pre-patent you can file. Then within 12 months, these 4 level you have to cross. Once your product is ready, then you can go for the patent filing. Clear? Now this in a one patent, there are many things. Here I am taking one example, like camera. So what is the, suppose first time the camera has been invented, that time somebody has patented. Now they have taken a design, what type of design they have. So say what type of shape they have, contour, configuration they have. So they can go for the design patent. Trademark means some company has made that particular camera. Then this trademark, they can go for the trademark. Copyright means the manual of that camera, how this camera is working, which button is using for which particular application. So these you can go for the copyright. So one patent, you can go for the patent, you can go for the design, you can go for the trademark, you can go for the copyright. So like in your mobile phone, so in the mobile phone you have 100 of patent they have filed. Then this product came in the market. Clear? So what type of claim you are doing from your product, what type of problem you are solving with the product, that is most important part. Clear? So these are the different patents, design, trademark, and copyrights. Clear? Like CD player. So people have a like 3D design they have patented. What will be the functioning of this particular product? What type of copyright they have? What type of trademark they have? So these all are patentable. Clear? So I would like to thank some of the companies like Jha and Agnihatri and Jha Associates, SS Rana. They helped me to file these patents. So these patent has been filed by me. Like 5 patent is already filed in healthcare sectors. Clear? So I have to take ethical approval from the medical hospitals, and I also taken the ethical approval from the institute committee. Then I have filed these patents. Clear? So if you are working in the healthcare sector, then ethical approval is must required. Otherwise, you cannot go for the patent filing. Clear? So that's all from my side. If you have any question, then please ask. If anybody have any question, then please ask.
Anybody has any question?
You can write in the chat box also. Please share mail ID. Yeah. You can search in Google. You can go Google Varun Bajaj, then you can find. Would you help in the patent filing? Yeah, I can help, but yeah, I can help. There is no issue on it. I can help it. If anybody have question, then please ask. Otherwise, we can close the session. Swati, can we close the session if nobody have any question?
Yes, sir. Yes, sir. Yes, sir.
Thank you so much. Thank you.
Thank you so much, sir, for your insight.
Thank you for listening me. Thank you so much.
Thank you so much, sir. Let's move towards the next speaker. So we are honored to have with us Dr. Prati Rajoria, Associate Professor at the National Law Institute, University Bhopal. Dr. Rajoria is a distinguished academician and author with expertise in corporate law, intellectual property rights, and legal writing. She has authored and revised leading texts on company law, published extensively in reputed journals, and presented her research at prestigious international conferences. We are delighted to have her with us today and look forward to her insightful lecture. Please, ma'am. Ma'am, please unmute yourself.
All right, sorry. Thank you so much for the introduction. I was trying to share my PowerPoint presentation. Just give me a couple of minutes. I'll quickly do that before I begin the session. Actually, I'm unable to find that. I was looking for that option for quite some time, but then I'm unable to find that option. If you could guide me with that, it would be really
There will
helpful.
be a sharing option below it, below your screen only, ma'am. With
Yes, that is there,
the-
but I want to. I am looking for the slide option that is there. Um, Give me a minute. I'll quickly do that. Yes, I have done it. I hope it is taking some time. Is it visible? The PowerPoint
ma'am,
presentation?
screen is shared, but nothing is visible. There is no PPT. We cannot see any PPT. Please share the PPT as well.
I think now it is visible.
Yes.
Is it?
Yeah, now it is visible.
1 minute. Let me go through. Yeah. Okay. All right. Sorry for taking so much time. I'm not very tech savvy. I need to be, I know, because this is what my topic is about in today's session. Because I was thinking I'm not the first speaker today, so I was thinking that I need not talk about the filing procedure because I joined a little early, so I was listening to the previous speaker as well for some time, and I saw that I'm sure that some of the speakers must have covered the filing procedure and how it is done, what are the different methods of different kinds of intellectual property rights. So I was thinking that I will talk about the basic principles, but I will talk about the new challenges that we are going to face in the current scenario. And as you can look at my title, it is revisiting the basic principles of intellectual property rights, and I will be talking about new challenges and issues that are there. Why we need to revisit the basic principles. So with that, I will quickly highlight some of the aspects. So I'll give you an example for this. Suppose there is this AI system that is in place. I'm presuming that these days everybody is using artificial intelligence. Everybody has access to Chat GPT and DeepSeek, and I'm presuming this because I also use all of these AI systems because they are very helpful. I'm not saying that you need to entirely rely on that, but I think these are some of the new challenges that you may face as somebody who is into education, or who's people who are teachers, academicians, or people who are research scholars. So I just wanted to start the conversation with this question, that what if you come across some new invention or maybe some new drug, pharmaceutical, some compound, there is some invention that has taken place, maybe in the pharmaceutical industry, and it is a drug which cures a rare disease, and this has been developed by some AI system. Now the question is that this invention or innovation that has been introduced, this is the subject matter of patent, of course it is, because it qualifies the NUN rule, that is novation, utility, and non-obviousness. Now the question is that who is going to be the owner? The patent will be filed in whose name? Who owns this invention? Is it going to be the researcher who fed the data or the information to the AI system, or the company that built the AI system, or the AI itself? Because AI relying on all the information that was fed to it and relying on whatever information it already, not just from the from the researcher, but from the already available data, the AI has come up with that compound or that drug. So who is entitled to this innovation? This is my question, and this is where the new challenges are faced, especially in terms of AI. So traditionally, when this concept of intellectual property rights was introduced, all of us know that this system was introduced because I'll change my slide. Give me a minute. I'll come to the next slide. I'm unable to change the slide. I'm sorry. I'll quickly do that. Now I can't see the screen. Sorry about this. IPRs, they were initially introduced because we wanted to incentivize people who had come up with inventions. They should be incentivized in terms of money. Some benefit should be given to these people who come up with innovations. So it was not just that there were questions with respect to public right and private rights, and there was this dilemma that what was the whole objective of introduction of IPR, because there were inventions, the wheel was invented, and a lot of inventions were otherwise also there, irrespective of incentivizing them. So the question is that do we need to introduce IPR and we need to recognize everybody's IPR to incentivize people? This is why inventions are taking place. But then there is an answer to that, that inventions are not entirely dependent on incentivizing the inventions, because people were inventing, scientists, they came up with inventions even without any expectation from the general public or from the government that they will be given some benefit for their invention. Then there is this private right versus public rights debate, that IPR are private rights. If we let people exploit their intellectual property rights for a dedicated time, what if that invention is very essential for the general public? In that context, the government has come up with measures such as compulsory licensing or voluntary licensing. We do have several provisions under every form of IPR to ensure that public has access to that. So there are exemptions, but we need to strike a balance. So this is the issue, that how do we strike the balance? So this was my question, that when with the new advancement in technology and the intervention of AI, when you come up with these kinds of inventions, who is going to be entitled to these inventions? Should we ban it completely or should we liberalize it? And if we liberalize it, to what extent we need to do it? This is my question. Because traditionally, when we look at the objectives of IPR, we can see that the whole idea of IPR was introduced thinking in mind that it was to protect human creativity and invention, which is not the case anymore. With the rise of artificial intelligence and the boundaries between human and machine contribution, we see that this difference is being blurred completely. So with that, I will proceed with the PowerPoint presentation, and we will quickly revisit the concept of different forms of intellectual property rights and see that what were the concepts and what kind of deviation do we see now. So this is the structure. We've understood the concept of property. I am sure you understand what is meant by property, and I'm presuming that since all of you come from diverse backgrounds and you are not just law professionals, I will quickly tell you that what is the concept of property. So property, there are three rights in any property. It is right to use, right to possess, and the right to dispose of. When you transfer your rights in that property, you transfer all three rights: right to use, right to possess, and right to dispose of. It can either be whatever is the form of property. When you're also transferring the right to dispose of the property, you completely transfer that right. So in case of intellectual property rights, when you are holding IPR in any property, which is an intangible form of property, you can also assign your rights to somebody else for the time being. Suppose you've come up with some invention, but you are not able to cater to the needs of the society, and not everybody has access to it. Then suppose there is a company which has come up with a drug and not everybody has access to it all over India, then the government will come up with schemes and provide for some kind of assignment of rights that let some other company also manufacture it and ensure that it is distributed to everybody in that country, and some kind of royalty will be paid to the company that has come up with that invention. So we've seen that intellectual property is acknowledged as a category of property. You can see that in the chart. And then intellectual property are also evolving over a period of time. Earlier, we could only think of patent, trademark, and copyright, but now designs, GI, and even trade secrets, these forms of intellectual property rights are also evolving. Now, when we look at the concept of IPR, all of us know that it is an exclusive right. Exclusive right has a very negative meaning to it, because if I'm using the term exclusive, it means that I have an option of excluding others from the use of whatever invention I have come up with, whether it deals with patents, copyright, trademark, industrial design, or intellectual property. So it is why I said that it has negative meaning attached to it, because you are using your right to exclude others from using it. So it is not an inclusive right. It is excluding everybody from the use of that intellectual property for a specified time. For different kinds of IPR, we have different terms or duration of protection that is given depending on the nature of that particular kind of IPR. So this, I will quickly go through this, presuming that you understand all of these concepts. Patents, the NUN rule, I have not mentioned that in the PowerPoint presentation, but to qualify as a patent, it is necessary that you follow the NUN rule. NUN is that it has to be novel, new. U is that it should have some utility in the context that it has some industrial applicability. The next N is non-obvious, that it should be non-obvious to the person who is skilled in that art. Suppose there is a mechanic who is into manufacturing of cycles, and somebody has, whoever came up with a tricycle for the first time, or a bicycle for the first time, came up with that concept for the first time. So somebody who had information or knowledge about, who is already skilled in that art, who's already a mechanic, and even mechanic who is already working in that field just cannot think of that concept, and somebody else has come up with that invention and qualifies, who fulfills all the eligibility requirement of this NUN rule, is now eligible to be granted a patent for that invention. Designs are, this is a very I would say sophisticated form of copyright. Design is granted for things which are appealable to your eyes. Maybe you've come up with a new shape, there is some different kind of pattern configuration, it can be in any format. A lot of designers, Anju Modi was the person who came up with she's a fashion designer, she came up with this revolution she introduced, saying that if you will go to Chandni Chowk or some of the areas which copy the designs of a lot of fashion designers, they are questioning it, that you can't come up with mass production of our design. So this revolution was brought about by a lot of fashion designers, that if we have come up with a unique design, nobody can copy it. So I hope all of you understand the concept of designs as well. Trademark is, now the concept of trademark is also evolving over a period of time. I will quickly come to that slide where I have discussed about trademark, and I'll tell you how trademarks are unique. So trademark, it covers a variety of things. It can be signature, name, device, label. It can be a combination of all of these things. It can be a combination of colors. It may have color. It may not have color. It can be, so trademark covers goods as well as services. For your services as well, you can come up with a trademark. And trademarks, they are now evolving. Why I am saying that they are evolving? Because now you will see that trademarks are not ordinary trademarks. These are some of the examples of trademarks that I've used in my PowerPoint presentation. You can have a look at it, which means that when you are capable of distinguishing the goods and services of my company or my business from that of somebody else, which means that it should have a connection between the consumers and the manufacturers or the service providers. So this is the purpose of trademark, so that the consumers can identify or perceive your goods and services. And over a period of time, when companies or businesses, they develop a reputation in the market, their trademark becomes a very recognized or well-known trademark. If at all there is infringement, then you can file a suit for passing off, for disparagement. But as I was telling you, that trademarks are not just ordinary trademarks. I am unable to play this video. I had included a video in my presentation. This was the video of the MGM movies, where there is a lion which roars. So this is what I was saying, that now trademarks are not in the traditional form. Trademarks have evolved. We are now giving recognition to unconventional forms of trademarks as well, which means that whether it is a sound, that can be a subject matter of trademark. This is the Taj Hotel of Mumbai, which was the first building in India which was given trademark for architectural design. This is also this is a picture from Dalal Street. This building was also given trademark recognition. So now we are recognizing trademarks which are not just logos or design logos or images of combination of colors, numbers of letters, but it is beyond that. So you will see that in some of the jurisdictions, even fragrance have been given recognition in the form of trademark. You are capable of distinguishing fragrance of one perfume from that of another, and trademark recognition is given. And sound, I have already told you. So trademark as a subject matter of IPR, it is evolving. It has evolved already, and it is still evolving. A number of unconventional trademarks are being recognized. This was an example of Indulekha hair oil, a bottle with this foam. It is a subject matter of patent, because it has industrial applicability. It is a very simple design. Even Velcro had patent. So any kind of iPhone, this is also a subject matter of patent. And the patent was given a protection for a duration of 20 years. After 20, initially it was 14 years, but with the industrial revolution and all of those things, and also because there were a number of multinational companies which were protesting against it, so patent recognition has been extended to 20 years. In case of copyright, it is lifetime of author plus 60 years. Trademark, it is 10 years, but trademark can be for lifetime because trademark is subject to renewal. So you can get it renewed every year. Patent cannot be renewed. Now, quickly coming to another category of this is also an example of unconventional trademark. This is a footwear designed by Christian Louboutin, which is where he's a very famous designer. He also collaborated with Sabyasachi in between to come up with some of the footwear designs. So this red shoe sole is his trademark. No other brand can copy it. The red soles are protected, and he has renewed it from time to time. This is an example of an unconventional trademark. Now coming to copyright. Copyright is, all of us know that it can be in any form. It can be either literary work, artistic work, dramatic work, even cinematographic works are given protection for copyrighted work. You write a poem, you write a play. So now this is what I was questioning. So when I started teaching, I was a fresher in 2013. I was assigned a new subject to teach, and I came up with my notes on maritime law. That was the subject that I was teaching. And then when I wrote my notes, at that time in 2013, there was no artificial intelligence. So I referred to different sources. I read the United Nations Convention on the Law of the Sea. I referred to a lot of case laws, and then I prepared my notes. And through my notes, I was teaching in class to the students. So I got in touch with one of the publishers, and the publishers asked me if I was interested in getting my notes published, and that was my original work back then. I got it published, and I sold the royalty rights also to the publisher, and now I'm paid for that. So this is how copyright was protected back then, because people had no access to AI. So now this is what I was asking, that what if I come up with, I still write notes, I refer to, but then for drafting of my notes, I'm not saying, some people may think that it is unethical, but I feel that it is ethical. Our job has been made very, very easier. So when I'm preparing notes, I structure my notes with the help of AI. I write my notes, and then I give prompts to maybe ChatGPT or DeepSeek, and I help them in, if there is a case law which is in detail and I just want the bullet points, I would copy paste the content that is there, and then I will come up with bullet points. But I always ensure that I check that information from the reliable sources. I refer to the original cases as well. I refer to the provisions as well. But in structuring my notes, how I'm going to deliver the lecture in class, for that I take AI's help. So now my question is that if at all I plan to get my notes published in the form of a book or in the form of a research paper, will I be able to do that? Should I do it? Will it not raise ethical concerns from the point of view of research and publication ethics? Is it right in doing it? Will it be a subject matter of copyright? I will come back. I just wanted to raise these questions. I will come back to these questions, and I will also respond to the answers to this. So these are some of the basics. So I'm revisiting the basic concepts. These are some of the examples of copyright which were there in the traditional sense, that somebody has come up with a painting. This is Mona Lisa. It had copyright protection. In the present scenario of somebody, there is a human painting, of course, it will have copyright protection. This is a book, wonderful book by Yuval Noah Harari on Sapiens. The title is Sapiens. A wonderful book. It is a subject matter of copyright. I am not sure if all of you have seen this painting or not, but then I have watched this movie. It is from the movie Welcome. It is Majnu Bhai's painting, there were a lot of memes on this painting. So for copyright, what is necessary, that It is not necessary that it should have some market value. If it is your innovation, completely human made, definitely it is going to be a subject matter of copyright. So even though it is, this painting may not aesthetically appeal to a lot of people, it is a subject matter of copyright protection. Now coming to industrial designs. So industrial designs are also given protection for initial 10 years. In most cases, it may be extended up to 15 years. And it is design is a little different from copyright. In case of footwear, cars, you can see some of the examples, designer clothes, all of these are subject matter of design protection. Then coming to geographical indications, I'm quickly going through all of these kinds of IPRs because I'm presuming all of you know the concept already. Maybe in the, I've reserved the last 10 minutes for the question answer section. So if you have any question, even with respect to the basic concepts, you please feel free to ask those questions. So geographical indications, all of us know the concept that if you've come up with some, this is not innovation, but you've come up with some intellectual property. If there is something, say for example, Nagpur oranges or the Banarsi sari, the Kanjipuram silk, all of these are subject matter of GI. The indigo prints on which are there in the Rajasthan, Jodhpur, all of these have protection of IPR in the form of geographical indication because the identity of that product or that service belongs to some identified geographical location. It is associated to some territory, region, or some specific town, city. And GI protection is not just given to one person, it is given to a group of individuals, association of people who are involved in the production of that particular product or service because it is used on traditional skills or knowledge that these people have. Now, in India, you must have heard that traditional knowledge was always part of Indian culture. We always had this rich Indian heritage, and there was a lot of information which was already there. Say, for example, you must have heard of the basmati rice, the turmeric, or the neem case, where U.S. Patent Office tried to provide patent protection to these things which were already there in India, in the Indian traditional knowledge. Every household was already using it. So for that, Indian government came in 1995. It has been quite some time. They came up with this concept of a traditional knowledge digital library. So we have TKDL where wherever there is some information, which is because we in India, we also have a number of tribes. And with each tribe, there are a set of traditional knowledge which are there, which is already there in public domain. But the issue was that there were a number of small tribes which were using some traditional knowledge, but it was not part of public domain. So now if you want to claim that something is already there in public domain, it is better that you upload it on the internet. Everybody has access to the World Wide Web, and then nobody can say that, oh, we were not aware of it because everybody has access to the internet. So traditional knowledge digital library is available in the digital format. You can have access to it through the TKDL website. And we are from time to time updating the information which is there with different tribes or in any part of the Indian territory. If there is some information which is part of traditional knowledge, we are updating it so that no other country end up misusing that information and claim any kind of intellectual property right over that. This is the organizational structure, as you can see in the PowerPoint, the slide. For patent, trademark, GI, and patent information systems, these are the mechanisms through which you can go for filing of different kinds of IPRs. This is a duration chart for duration, that for each kind of IPR, what is the tenure for which protection is given. In case of trademark and design, you can renew it, but in the rest category, and in case of GI also, you can renew it. But in other forms of intellectual property right, it cannot be renewed. Now, this is an example of a Coca-Cola bottle where all kinds of IPR you can see. Trade secret is another category of IPR, which is based on contracts between the parties. We do not want to disclose it. It is recognized as a form of IPR, but we do not have a dedicated legislation for trade secret. This Coca-Cola, the drink, it is a subject matter of trade secret. But the bottle, it is a subject matter of trademark. The logo is a subject matter of trademark. The bottle's shape is a subject matter of trademark. The opener, the cap, and the bottle, when you open it, that is a subject matter of patent. The text is a subject matter of copyright. So you can see in just one example, you can see a lot of copyright, you can see a lot of combination of different forms of intellectual property rights. But if there is a company or an organization that wants to get protection for this, they will have to follow a separate procedure for each category of intellectual property right to get it registered and get it recognized. If you want to do it on national level or on international level, we have the Paris Convention, and we have the Patent Cooperation Treaty, PCT, as well. So there are different Berne conventions. So based on different international treaties, you can get intellectual property registration for different methods of intellectual property rights at your domestic level, that is within the country, and also at international level. These are some of the examples of different forms of copyright. The Kolhapuri chappals are example of geographical indication. The Apple logo is an example of trademark. Then this fan design it is a subject matter of patent because it is a combination of this qualifies the NUN rule. There is this design is a subject matter of industrial design. The Coca-Cola, the drink is a subject matter of trade secret. So I hope we've covered all forms of intellectual property rights. So now I'll come back to the first question that I raised in the beginning of my session, that all of these things, all the kinds of intellectual property rights that we look at, there is a presumption that everything will be created by the humans, because back then when Edison came up with electricity, the creation of bulb, or all kinds of inventions that were taking place, all of this was done by humans. There was no machine learning, there was no artificial intelligence. We did not have computers in place, because computers also came into existence in the 1990s and in India especially, they came only after the new economic policy. That is when we allowed liberalization, privatization, and globalization. And this is how we were open to machines. So it was after this phase of the industrial revolution in the 18th century and the later developments that creativity was also, it was not just human creativity, but it was a combination of human as well as machine learning. So one issue when computers were introduced in the 1990s, we faced that what if there is a computer program, should it be given patent protection or copyright protection? So for that, we came up with a solution that if you have come up with some computer program, which is just the program, then it is subject matter of copyright protection. But if that computer programs can only work with a combination of some hardware in the computer system, then it can be a subject matter of patent. So that issue was resolved. But over a period of time, we faced some of the other issues as well, especially after the intervention of a lot of AI related tools or AI related intervention that was made in the field of research. So I will share some information with you that when we look at AI as a creator or inventor, so at national level, we do not have any principle as such, because India is not open to, when we look at the Indian legal regime with respect to intellectual property rights, we see that India is not open to giving recognition to artificial intelligence as an inventor. But there are certain other jurisdictions which have recognized it. One of the examples that I wanted to discuss was of the Zarya of the Dawn, which was a novel which was written by one novelist in the USA. But an issue with this novel was that it was a combination of some text, some original storyline was there, and then there were certain graphic images which were used in that novel. And for the generation of these graphic images, there was this AI tool that was used. This AI tool was Midjourney. This was the name of this tool. So in 2023, which is recent only, the US Copyright Office came across this issue that generally for novels, you give recognition to the novelist, the author of the novel. But the issue was that whether the entire novel can be given copyright protection or not. So the US Copyright Office came up with a conclusion, and they said that when it comes to granting copyright for the human written story, of course, we can grant it because it is your creation. But they refused granting protection to the AI generated images. So I think in this case, they were right in doing so. It was necessary because it was, you've not done it. The graphic images were generated by the AI tool, which was this Midjourney. But maybe this is my question, that if suppose I have given you instructions that maybe I want a hut for that graphic image, with that hut come up with a tree, add come up with a lake with that in the lake, add some fishes in the lake. So I am the one who is giving all of these instructions, but I'm not the one who has come up with the generation of that image. I'm not painting it. I'm not drawing it. Should I be given copyright protection? Even in the Western world, people are not okay with AI generated images. They will not be given AI protection. They have not done it, even though the prompt is given by the author. The reason in this case, as was given by the US Copyright Office, was very simple, that only human creativity is protectable. AI being a tool, AI being a machine, it cannot claim authorship over anything. Now the contrast is with the UK case. You look at the UK case, which is included in the PPT. Look at the provisions of this section under the United Kingdom's Copyright Design and Patent Act of 1983, Section 9, which talks about computer generated works, and it says that the author is the person who made the necessary arrangements, which means that in UK the user prompting an AI could in theory be entitled to copyright protection. And in India also you will see that there is when you read between the lines, you will be able to figure out that the wording is such that the author is the person who made the necessary arrangements, which means that if the author is giving prompt to AI, ideally the AI should be given copyright protection over the work that is generated by AI. So should AI generated work be a subject matter of copyright protection? Maybe we'll discuss it at the end of the session. With respect to patent, there is one more case, a recent case, which I wanted to highlight, which relates to the Debus case. Here in this case, AI system, which was named Debus, it invented two products. One product was a food container, and the other product was a light emitting device. So the applications were filed for the worldwide applications were filed for the purpose of patent protection for these two products, which were not generated by human, but through a prompt that was given by humans to the AI based tool, and they came up with the generation of these two products. And at international level, for the protection of this invention, application was filed in the UK office, US office, European Patent Office, South Africa, Australia, everywhere. And then when we look at the outcome, the US Patent Office, the UK Patent Office, the European Union Patent Office, all of them said no, saying that this invention is not a human invention and therefore we cannot grant it patent. In South Africa, they granted patent, saying that the prompts, it was ultimately the human that fed the information in the AI system. Australia also briefly accepted it, but when it was challenged in the High Court in Australia, it was overturned, the decision was changed, and even Australia denied giving patent protection to an invention which was AI based. So when we look at the conclusion of this, I would say that recognizing AI as an inventor, it raises very deep problems. The reason is when you look at the legal accountability, which you can easily do in case of humans, you can't make AI legally accountable with respect to ownership disputes also, because AI is not a separate entity. It is not a recognized legal person. At least in India, it is not. Now, maybe the company which owns AI will claim ownership over that product, and not, it will say that don't give it to that AI, because AI is not a person. It is not even a legal person the way companies are. And companies will claim ownership, so it is going to give issues. A lot of disputes will arise with respect to the ownership of that product. And in case of copyrighted work, there are no moral rights as well. In case of AI, they will not be able to claim moral rights the way they are claimed by authors or singers with respect to the copyrighted work. It is not just economic rights that they claim, it is also moral rights, because if suppose I am an author, I will have that kind of attachment with my work, but maybe AI will not have, because it is an artificial person. And so this is one aspect. But on the other hand, if I say that if you will deny patent protection or any kind of intellectual property right protection to AI generated works, in that case, maybe a lot of companies will, it will push the companies to rely on trade secrets, and they will not disclose the information with anybody, even if it is useful to the general masses, because they will have a direct response that we are investing in the research and development of our AI systems or our machine learning systems. If it is our money that is spent and we are not even given any kind of incentive, we are not able to commercially exploit it after getting intellectual property recognition in that, then why should we be disclosing it to anybody? Let us keep it in the form of trade secret. So maybe it will also backfire. So when it comes to data and some of the training challenges, I would say that AI does not invent in a vacuum. It relies on a lot of information that is already available on the internet, or it is fed by somebody who's using that AI. I will give a prompt to that machine that this is how I want things to be structured. So this raises a new set of questions. First question is that if AI is trained on copyright material, which is books, music, images, or all the information that is available on the internet, does this not constitute intellectual property rights infringement? Because AI is using all of this information without seeking permission from the inventors, from the innovators, or the authors of these copyrighted information that is available on the internet. And second question is that who owns the output of AI generated work? Who owns the output of AI trained on such data, which is otherwise already a copyrighted or protected work? One such example that I can think of is of it is of Getty Images, which I have included in the PowerPoint presentation. All must have used Getty Images at some point in time. So Getty Images, they sued Stability AI in the UK because they claimed that its copyrighted images, they were used by Train Stable Diffusion without any kind of prior permission. And similarly, a lot of authors in the USA, they have sued OpenAI as well for using their work to train large language models. So AI is also relying on a lot of information on the internet, which is otherwise protected. So the question is that is training AI on copyrighted material, is it fair use, or will it be included in fair use exception, or will it not be infringement? Ideally, it is infringement because you can't, even if you are AI, you are not a legal person. If you are using somebody else's information, somebody else's innovation without seeking permission from that person, then you are coming up with some invention. This is a clear infringement of the right of the work of the intellectual property rights holders. So the law with respect to that is, it is absolutely unsettled. The Western world countries have also not come up with anything. The courts are still debating it. Some argue that training is transformative like human learning, and thus it is fair. So in case of AI also, it should be allowed. But then there are people who also argue that it also undermines the market for original work. Because AI, of course, it is more capable of doing things compared to, now this is something controversial that I'm saying, but of course, machine is more competent, except that it does not have feelings or emotions or empathy. But otherwise, when you ask machine to do some mechanical job, it will be in a position to do it better compared to any human. So with respect to data and training, there are a lot of implications for researchers. One is that if you're using AI generated text, images, or data in your thesis or in your publication, you need to be very cautious about transparency. It is better that you maintain all the transparency. You need to be very crucial. You cite your tools that you are using, acknowledge that you're using AI. But even if you acknowledge it and then you write some research paper and you send it for publication, it will be outrightly rejected because a lot of journals are not okay with publishing AI generated work. In fact, this is one of the issues that a lot of journals and publishers are facing, that most of the work that they are receiving now is written by AI, or there is some assistance that is taken by AI. But I think we need to come up with some guidelines, like the government do it. They should come up with some framework to clarify that what percentage of AI assistance should be allowed. So if you use AI, you will be risking your work to plagiarism, or there are going to be some ethical lapses, of course. Then when we look at AI and innovation, there are a lot of gaps. When we compare opportunities versus the gaps that are there, we see that while these legal battles, they are still unfolding, we are still in the process of acknowledging that AI is there, and we need to work together with it. And we know that AI is also revolutionizing research. Should we come up with a ban? I don't think so. A complete ban is required. When we look at DeepMind's AlphaFold models, that because they came up with a prediction that there were some structures, there were some 200 million proteins which were there, they predicted all of these proteins, and there was a breakthrough in technology, and AI systems, they were generating hypotheses, they were designing experiments, and they were also they are also involved in speeding up drug discovery. So I think complete ban on it is not required, because it is, when you look at research and development, AI has contributed a lot. But here lies the gap in this, that if such outputs are not patentable, will companies invest billions of their money in AI-driven research and development? And then there is a contrary view as well, that if every AI-generated output is logged behind patent, does it not restrict access for researchers? Because researchers would want to have access to it, maybe for further research. So this creates a policy dilemma: how to balance incentives with openness. This is the question. As researchers, I am presuming that all of us are researchers, as academicians and as students, all of us are contributing in some way. Many argue that let us proceed with the middle ground. I am one of those many. I am in that. I favor that perhaps there are new forms of protection. There are short-term protections. Few generous rights are also there for AI-generated works. I think let us take a mid ground. AI is necessary. We can't deny the fact that AI is there, and we need to learn to work with it. But how do we do it is the question. When we look at some of the policy and governance debates, we see that WIPO has taken up some initiatives. It has been holding consultations since 2019, but they have not come up with any global rules as of now. The European Union has also passed an AI Act on regulating AI risk, but not IP ownership. So they have not addressed that concern. United Nations has also formally required human authorship and inventorship. So they have completely denied AI related inventions. When we look at India's position, Indian copyright and patent offices, we still continue to require human contribution. AI is currently seen as a tool, not as an author or inventor. So we've not recognized AI at all. But there are debates in India that are ongoing, because India, at one point, we are saying that we need to push towards digital India and AI is for all. We need to accept all of those strategies, but at what cost? That is the question. So when we conclude, I'll quickly conclude it with implications for research and innovation. So for all of you as research scholars or academicians, I feel that the debate is not abstract. We need to talk about it because it touches our daily lives. First, there are plagiarism risks, because using AI for writing or coding without attribution can undermine research integrity. Second, authorship issues are there. Journals like Nature or Science, they've explicitly banned AI as co-authors and require disclosure if you are using AI. So if such high quality journals have done it, I'm sure a lot of journals are not okay with AI assistance at all. Third thing, patenting your work. If AI was used, you must clearly explain your human incentive step that is involved. You will have to clearly specify that when you are coming up with provisional or complete specification during patent filing. And fourth thing is open science versus secrecy. You need to consider carefully that when to publish patent or keep results confidential, because you can also go for trade secret if you feel that you will be able to commercially exploit your invention. And if you disclose it, you've done it using AI, and if you disclose it, you will not be given any kind of incentive. So you can still use it in the form of exploit it commercially in the form of trade secret. The safest response is that you follow a path of transparency, always disclose where and how AI has been used, document the human intellectual contribution that you've made. And with this, I will just conclude that AI challenges, they are there. There are a lot of human-centered foundations that focus on IPR. The court and policymakers, they are still struggling, and they are not okay with the adoption of AI as the owner of intellectual property. And the researchers, they must act responsibly, very responsibly, and they should understand the risks and follow the evolving norms. So with this, I will conclude, and I am open to questions. If you have any questions, please ask. Let me know if there is a question. I hope I explained the risks with respect to IPR and the use of technology to all of you in an effective manner. In case you have any question, please feel free to ask. Or I will presume that it was all very, it was self-explanatory.
I think it was self-explanatory, ma'am. I hope, I think nobody has any question.
All right.
So, okay, thank you so much, ma'am. I extend my heartfelt gratitude to all our distinguished speakers for gracing us with their valuable time and insightful lecture. We look forward to continue learning and collaboration. Once again, express our profound gratitude to all of you. And thank you so much, everyone, for joining us today. We are ending this session and we'll join for valedictory later on. So currently we are moving forward for the lunch. Thank you so much, ma'am. Thank you, everyone.